Thank you, Anne, very, very much. On behalf of the board of the Estate Planning and Probate section, welcome, virtual welcome to everybody. And I understand today we have nearly 90 attendees. As Anne mentioned, every year we're just so fortunate to have Mechanics Bank generously sponsor this event. And so before we start our program today, I'd like to extend a special welcome and another thank you to John Osborne, who's with us today. John's the director of the trust services at Mechanics Bank, and I'd like him to say a few words. John?
Thanks, Catherine. Good afternoon, everyone. As Catherine mentioned, my name is John Osborne, and I'm the Director of Trust Services for Mechanics Bank. On behalf of all of us at Mechanics Bank, we'd like to welcome you to the 27th Annual Estate Planning Symposium presented by the Contra Costa County Bar Association. We love this event because it's a wonderful way for us to connect with you, our customers, supporters, and referral sources. We appreciate each of you, and we're so glad that you could be with us here today. Hopefully, Mechanics Bank is not new to you. The bank was established in the East Bay over 115 years ago, and the trust department, now at 55 years old, is celebrating its Emerald anniversary. The deep green gemstone is known to symbolize eternity and commitment, which makes perfect sense to us as we remain deeply committed to our local communities and to the values upon which we were founded: trust, lasting relationships, teamwork, and genuine care and pride in what we do. Since last year's symposium, we purchased Rabobank NA. This added 100 branches to our network, 13 billion in assets, and 1,500 new mechanics to our family. This acquisition also expanded our trust department, adding $500 million in assets to our portfolio and adding trust personnel in San Luis Obispo office and our Santa Barbara offices. Our footprint now expands the entire state of California, and with combined assets of 17 billion, we are California's 5th largest state bank. Like many of you, we wish we could be all together in person at the Lesher Center. However, as you know, the California wildfires and COVID-19 continues to affect the way that we live, work, and interact. And while many other events are being canceled, we appreciate today's organizers pivoting to a virtual conference and symposium, and we look forward to an informative and educational afternoon. Please enjoy the symposium, and thank you to from all of us at Mechanics Bank. Catherine?
Thank you so much, John. So I'd like to move ahead and start with our very first program, which is the good, the bad, and the ugly of gun trusts. Today we have our board member, Matt Toth, who's a moderator, and our presenter, David Salvin. David is an attorney licensed to practice in both California and Oregon. He's been practicing for about 25 years, and he's consistently maintained that the best representation is achieved through direct and straightforward communications with his clients. As a lifetime NRA member, he has over 30 years of firearms experience, and he spent his entire working life with shooting and collecting firearms. Through his criminal defense practice, and now with his gun trust work, David combines his hobby and love of firearms with his professional career and professional experience. Matt, David, the floor is yours.
All right, thank you. So if you have any questions along the way, our plan is to have you put them in the questions and answers, and I will stop David and we will answer your question, hopefully immediately. David, it's all yours.
Good morning, everybody. Good afternoon. I am David Salvin, and as I was so beautifully introduced, I am an odd hybrid. I primarily practice in the areas of estate planning and in criminal defense. And overall, I began to merge my interest in firearms with my professional career. And so I've become something of the gun guy. So if there's a gun, I'm your guy. And that has very much been the case in criminal defense, of course. I represent people who are, of course, charged with all kinds of offenses, but specifically do enjoy working on cases with regards to guns, configuration of guns, and and whatever. And here in California, we are fortunate or unfortunate enough to have such Byzantine firearms laws as to entrap quite a bit of people and quite a bit of problems regarding firearms in all different aspects, which kind of leads me to the topic of the seminar, which you've all haplessly wandered into, and which Matt has very graciously asked me to bore you with for a little bit. And that is the interplay between firearms law and estate planning. Hitherto, estate planning has been the dusty old tome of the legal world, and firearms has always been sort of on the outside rim of criminal defense. And we deal with it when everybody thinks of firearms law, they think of the gun runners, or they deal with drug gangs, or whatever else it is that people imagine or fantasize. But really, the juxtaposition of these two particular fields is all of our clients. And we used to see it primarily in the estate planning realm, where grandpa dies. All right, grandpa dies. He brought home something from the war. Or pick your war, it doesn't matter. He might have brought home some war trophy. But that has very much been updated in these later times, because now California has moved to ban and make illegal so many different types of firearms that it's no longer just grandpa or great-grandfather dying. It's now dad's dying, or son, brother, it doesn't matter. Somebody leaves firearms in connection with an estate. And as we all know, it's incumbent upon us to help our clients administer those estates, both plan for them proactively and also deal with them retroactively after the passing of this last set law. So with that, we talk about proactive steps, things like gun trust. At its most simple level, firearms trust are nothing more than a trust, just like we all draft and we all well know, with a few little twists. And so what I hope to do today is kind of explain where we get gun trust, why they became a thing, and what they might be useful for in the future, and then broaden out that piece of information, and then apply that more broadly to firearms in the estate process, both preemptively and then retroactively after the passing. We all have estates. We all have dealt with clients who have, grandpa's such and such, or maybe it's brother-in-law's such and such, and we all got to deal with that. Well, in the context of California firearms law, that becomes real important, because our clients are going to be looking to us as to what to do with these firearms. How do we deal with them? What are they? Are they illegal? How do I transfer them? What all happens? And it's a bit of a black box for most folks who are not gun folks. So I'm hoping to shed a little bit of light on that, perhaps bore some of the folks who are gun guys and girls here on the board, but perhaps shine a little bit of light on others. So with that, I'm going to attempt to share my screen here and see if we can't, Matt, am I sharing my screen properly here?
Yes, you are.
Excellent. Okay, so we are talking about gun trust, firearms in estate administration. And so with that, we sort of look to the beginnings, okay? And believe it or not, the beginnings of firearms trust, in fact, firearms law in the modern era, begins with the outlaws. And we're talking about these two folks here. Many of you folks may or may not know, good old Bonnie and Clyde. And they actually mark the beginning or the genesis of modern firearms law. But the beginnings of this firearms law is not the people, all right? And we know through historical research and whatnot that the people became something of legends. Whether your stance was pro or anti-gun or pro or anti-law enforcement, they became the Robin Hoods of the era. There at the late 1920s, early 1930s, we're in an era of lawlessness that involved multi-territorial pursuits and things of that nature. And the people became legends. And of course, we all know John Dillinger and Bonnie and Clyde. And these people became sort of touchstones, and they became cultural hallmarks. But it's not so much the people. What scared the legislatures, what gave them chills at night was not the people, all right? We've had bank robberies in the past, and we've had outlaws in the past. What gave them nightmares were the weapons. Bonnie and Clyde, for example, were very good with their firearms, and they modified their firearms, and they used incredibly sophisticated firearms for the age. And here in this slide, we see in the upper slide there, Ms. Clyde Barrow's BAR, Browning Automatic Rifle, which was designed to be used in the First World War. It's a full power 30-06 semi-automatic light machine gun, capable of incredible firepower. And what Clyde did was he cut off the barrel and he cut down the stock so that he could wield it very adeptly in short, small places like cars or banks or small buildings. And the weapon just was able to cut through just about anything other than perhaps the absolute engine block of a car while disabling it. And that weapon came to civilian use or ability to get through the First World War. We did not field that weapon in any great numbers, and that left a lot of them around to fall into the hands of outlaws such as Bonnie and Clyde. Similarly, you see sawed-off shotguns in the upper portion here. So, you know, again, these are firearms with incredible firepower that are able to be wielded in very small spaces and concealed. The lower picture there, we see that the famous Tommy gun, the Chicago typewriter, made famous for the gangster wars in Chicago. That firearm, designed by Colonel Thompson for this First World War, was meant to be a trench broom. It was a 45 caliber, pistol caliber firearm, a carbine, that was able to, with a cyclic rate of between 650 and 750 rounds a minute, just lay down a hellacious field of fire. And again, with a 50-round drum, as you see here in the picture, you can imagine the amount of firepower a person might wield. That firearm actually also did come with a 100-round drum. So when used and put in the wrong hands and used for the wrong purposes, you can see the type of firepower that was now available to the general public. And in fact, in the late 20s and early 30s, the Thompson submachine gun was available. You could walk into a drugstore, you could walk into a hardware store, you could walk into a gun shop and just pick one up. The only thing that really stopped you from doing so really was the cost. These were pretty expensive, which is why the US didn't field them in any great numbers. But at the time, they were probably something in the number of about, you know, $150 for the average consumer, which, you know, in today's numbers might be $8,000 or $10,000. So, you know, your average plinker or gun nut wouldn't necessarily be able to go in and pick one of these things up. But outlaws like Bonnie and Clyde were, and of course the gangsters were very quick to seize on them and relish them for their firepower. So it all begins. The stage is set for the National Firearms Act. Prior to that, there had been no federal gun laws to speak of. It was a kind of hodgepodge of state laws and what have you. And the NFA, we call it the National Firearms Act, the NFA in 1934, began that. But a lot of folks don't realize that that particular act was not a criminal law. It was not a penal code. It was actually it basically dealt with excise tax, and it was a primarily financial one. It was a transfer tax. And so the Congress passed this and essentially gave the Treasury Department the ability to enforce this law and enforce this excise tax. So they didn't actually ban fully automatic weapons. They didn't ban assault shotguns or anything of the nature. They didn't ban them like we would think of today. All they did was make them terribly, terribly expensive to get. So the NFA, the National Firearms Act of 1934, had designated a whole bunch of different items as controlled items. And these are things like short barrel rifles, short barrel shotguns, silencers, machine guns, destructive devices, all the goodies that we kind of see in the war movies today, or we think of when we see Bonnie and Clyde in their pictures. So these kind of items, you know, obviously the first, machine guns, okay? These are basically fully automatic weapons. And again, in the early 30s, late 20s, they were available to the general public for simple purchase. You didn't have to have any kind of licensure. You didn't have to have any kind of, a permit to get one. You could just simply, if you had the money, walk into your local five and dime, your local hardware store and pick one up. So machine guns were regulated at that point. And so you needed to get authority basically to buy such a thing. And the same thing is true with what we call short barrel rifles, basically any kind of rifle with a barrel under 16 inches. Prior to that, you know, Clyde could simply get his BAR and hack off the barrel so he could hide it under a trench coat. And he was violating no federal law. He was violating, frankly, no law whatsoever. until he used it, of course. So we look at short barrel rifles as being kind of under the auspices of the National Firearms Act. First time that these sort of things were put into play. Additionally, we have short barrel shotguns, and you see an example here of different kinds of short barrel shotgun. And again, it's very much like what we see, simply taking a hacksaw to a long barrel rifle or long barrel shotgun and cutting it down. The shotgun has a smooth bore, as mentioned here, which means it doesn't have any rifling. You can simply cut it off. It doesn't take any particular skill or adeption and machining to do it. So a lot of folks cut them off, and as you can see, a 12 gauge shotgun, the size of a pistol like that, or the size of a very small, a small rifle size thing, can be hidden very easily, and of course provide a lot of firepower for a wrongdoer. And so they were included into the NFA, this National Firearms Act. Also silencers. It's kind of counterintuitive, but a lot of folks think silencers actually silence a firearm, making it impossible to hear. But in reality, it doesn't. It just deafens it, dampens it a bit. But you still have to have ear protection on, and of course, you still have to be aware that the firearm is going to make noise. It's just going to make less noise, and it's going to contain the blast. But for whatever reason, the NFA decided that these things were assassination tools, and only bad guys would ever need to use them. And so they included suppressors into the National Firearms Act, and it requires the National Firearms Act okay to buy a silencer. And then you have even more exotic kind of things, and then we call them destructive devices, essentially. And these were both under the 1934 Act and again in the Omnibus Crime Act in 1968. And believe it or not, it is possible, and it is entirely feasible in other what we call free states other than California, to own a field gun like you see here in the picture in the upper right. It's a 37 millimeter or 57 millimeter anti-tank gun. Yes, you can own them. In order to do that, anything with a barrel or caliber over .50, or in California .60 or greater, requires to be registered under this National Firearms Act. It's not illegal. You're welcome to have them. You have to get what's called a tax stamp in order to get such a device. And here you see the coveted tax stamp. So you see here the $200 tax was put in 1934. And the only reason that we're able to readily have firearms such as that, whether it be antique field pieces or machine guns or whatever, is a very, very small quirk in the law. And that is, they forgot to adjust for inflation. Quite frankly, that's all it is. In 1934, the $200 tax was prohibitive. They never figured anyone in their right mind would ever be able to afford such an amount. As you can see, the equivalent in 2019 dollars is almost $4,000 to get this stamp. You have to get one of these tax stamps in order to purchase and maintain any of those destructive devices, any of those machine guns, silencers, short barrel rifles, whatever, all those what we call NFA items. You need to get a tax stamp. And you need to get one for each and every single rifle or destructive device or silencer that you want to buy. So here in 2020, $200 doesn't sound like a whole lot, but of course back in the day it was quite a bit, and so you had to get it. And in today's parlance, obviously the money isn't terribly expensive, but the time period is involved. In order to get this tax stamp now in free states, and I say that with deliberate intent, California does not allow for any of these devices. So you don't really have to worry about many or any of these devices in your local estates. Or any of local Californians. All of Californians can't get any of these things, but every now and again you might be dealing with a state from a free state like Oregon or Nevada or Texas or, well, basically most of the other states. So anyway, you'd have to get this tax stamp. Right now, the waiting time on a tax stamp is somewhere about 24 to 34 weeks from application for the feds. So here we see this, the process essentially to get these firearms, okay? So you have this system set up under the NFA to get this tax stamp, and you have a whole process, and it's under 27 CFR 47984. Don't need to write it down. It's pretty arcane, but nevertheless, the important thing to take away is this Form 4 is what you need to file to pick up your new firearm. be it a machine gun, be it a war trophy, be it whatever. You have to have this Form 4 filed in order to get the tax stamp. And most importantly, the individual trustees must file with appropriate law enforcement to get certification. In other words, you had to go to your local law enforcement and say, please, governor, may I have one? Local sheriff department, can I please purchase a machine gun, a short barrel rifle, short barrel pistol, whatever it is. So you needed the chief legal enforcement officer's okay. Well, as you might imagine, many of them, I'm thinking of Boss Hogg in the Dukes of Hazzard, in Hazzard County, would probably have no problem signing off on that kind of stuff. But a lot of law enforcement officers just refuse to do it. If you're in the suburbs of Chicago, or if you're, somewhere maybe in the downtown Atlanta, even though it's legal for Georgians to have such weaponry, you may not be too fond of getting your name put on the application for the sign-off of a machine gun in downtown Atlanta. So quite obviously, a lot of times the law enforcement officers wouldn't sign off on these things. So we have this issue of, all right, what are we going to do? So reading further into the NFA Act in 9.4.22, there is, of course, everyone's favorite loophole. And that is that for individual buyers, if you're just average Joe lunchbox, 6-pack, you want to get your machine gun to go plink on the weekends, you've got to get the okay from law enforcement. Well, that may or may not be possible, but rules don't apply to everybody, and as has always been the case, and I guess always will be, partnerships, companies, associations, trusts, and corporations don't have to get application. They don't have to make application through law enforcement. All they have to do is give notification. Aha! Well, there you go. The gun trusts are born. Now, of course, in order to get these items, you can go partnership. As we all know, we can form partnerships, sure. Companies, corporations, sure. But corporations, as we all know, here in California, $800 a year for the estimated taxes on a corporation alone. Kind of gets expensive for somebody to have to keep paying year after year after year to have their favorite machine gun or whatever it might be. So we hit upon the trust. Okay. Well, trust, as we all know, don't cost anything in terms of filing or registration. They're essentially once they are created, they are immortal, at least for most purposes, for the purposes of the machine gun at least. Grandfather, father, whomever it is going to be able to have that trust as long as he shall live. And then down the road, rule of perpetuity is notwithstanding. So, a trust is relatively inexpensive to form. It's relatively simple to form. Doesn't require any registration or undue involvement by any law enforcement or outside power. It's not like a deed. You got to file with somebody. So obviously, the trust is seized upon as the vehicle. Okay. And gun trusts were born, and they were used extensively throughout, pretty much the 60s, 70s, 80s, 90s, until about the year 2016, when the ATF suddenly decides that these machine guns, destructive devices, or what have you, no longer require law enforcement sign-off. In fact, it only now requires law enforcement notification. So rather than going to your local law enforcement officer and saying, please may I have one, you now only need to go up to them and file a paper and say, here, by the way, I'm getting a machine gun. By the way, I'm getting, a field gun or whatever it may be. You can get those. So the idea being is you don't have to go in there and you don't have to ask permission. You only have to tell them. In fact, now, gun trusts are generally disfavored ways of going about doing this for one reason, and that is that the registration and the regulations regarding this require that all of the trustees of the gun trust now have to go through the same background check as the purchaser. So now, instead of dad going out and doing all this and getting his stuff in and having all the various trustees just kind of following in line, now mom and the kids and anybody else whom he might want to make trustees of this trust have to undergo the same extensive background check that you would otherwise have to do in order to get one of these firearms. And so rather than doing that, we don't want to go through a gun trust for that anymore. All we need to do is file the notification with law enforcement. So gun trusts are disfavored for the primary purpose they were originally created for, which is to get all of these NFA items. And again, this is not terribly germane to California in as much as you really can't get any of these items in California. They're specifically banned. So this is really just more edification, and keep an eye out should in fact you see something along those lines in one of your estates from a free state. But they do still exist. Gun trusts are not dead, but they fall back into the primary testamentary purpose that we would ordinarily expect any trust. So in considering what to do with a gun trust, if you know, your client comes to you and says, you know, look, Mr. and Mrs. Attorney, I want to do a trust, and I've got cups and chairs and tables in the house, and you know, stocks and bonds, and I have this gun collection. What should I do? All right. Well, you got to start thinking about whether or not you need a separate firearms trust to begin with, because a trust is a trust is a trust. It's been defined as a bucket, right? We all know firearms trusts, any kind of trust, it's a bucket to put stuff in, and it's a conduit to carry down further to your progeny or further generations. So you first have to make the decision, do you in fact need a firearms trust? And I would posit to you that you don't. You don't need one unless until you have a collection of some substantial worth or sophistication. 20, 30, 40, 50 guns. The newspapers might call that an arsenal. In Texas, that's called a good start. So, you know, it's not uncommon for people to have collections of 50 or 100 firearms. So the question really then becomes not so much, do you need to draft a trust, but really, you know, why would you need a trust? Why would you need a firearms trust separate from any other trust? And of course, you know, we all know we can prepare trusts for anything, right? We can have pour-over trust, we can have special needs trust, we can break down all trusts in all different ways. So first and foremost, you look to see, all right, well, what do I got going into the trust, all right? Do I have a substantial collection? Is it historical? Is it expensive? Is it voluminous? Anything along those lines. If you're talking about your average, you know, guy with his Glock and a couple of bolt-action rifles, I'd maintain you don't. Put it into your trust like any other. It's a personal property item, just like any other. With, again, one caveat, and that is firearms, kind of like cars, have a dual life. We all know that automobiles have both a registered owner and a legal owner. So if you cruise down to the Mercedes store and you go and you buy a brand new Mercedes and you have a lien on that and you're making payments to Mercedes Financial of the United States or America or whatever to buy that car, you'd better believe, well, you're the registered owner, right? The DMV wants to know who you are. You're a human. They want to know who's driving it, where it goes. You better believe that the leasing company or the lending company also has their name on title. Well, firearms are kind of the same way because firearms must be registered to a human being. All firearms, whether they be NFA items or not, they have to be registered to a human being, but they don't necessarily have to be owned by that same human being. 99% of the time, that's the case, right? You go out and you buy a pistol, you stick it in your nightstand, whatever the case may be. You know, it's registered to you because you purchased it, you went through the background check, it's in your name. That's fine. But we get into the very odd circumstance where if you're married when you go and buy that pistol, as we all know, that pistol isn't yours and yours alone. It's actually community property. And your wife or your husband owns an undivided 1/2 interest in that firearm, even though you may be the registered owner. So we have to kind of look at that and we say, okay, you know, who the owner is going to be and or who the registrant is going to be. And most of the time it's the same person, but nevertheless, we kind of look at that. And we see the odd distribution of that in Hollywood movie prop companies. Only here in California, the only people who can really get these unique NSA items, fully automatic weapons and stuff like that, are the prop houses, are the movie companies. And they have giant warehouses full of guns that are basically used in movies. And these firearms are worth millions, literally millions and millions of dollars because they require this licensure to get. In California, you would need a destructive devices permit, you would need a machine gun permit, you need an assault weapons permit, and a high capacity magazine permit. That's, if you guys keep in track, 4 separate permits to have one gun to be used in a movie. And then if any of you have ever seen Saving Private Ryan or the Matrix movies, you know they have thousands of them. So Obviously, those firearms are very expensive. They're not owned by the human whose name is on that certificate, is on that license, because the company owns them. So if you've got Industrial Light and Magic or whomever it might be who owns the guns, they can't have the permit, because permits have to be held by humans subject to arrest, by the way, which is the thinking behind that. So we have this dichotomy where you might not necessarily have the same person registered on the gun as the person who owns the gun. We'll get a little bit more into that in the nuts and bolts of dealing with firearms in a state collection. But so to begin with, your clients come in and say, hey, I'm looking for a trust, and my family trust, or do I need a gun trust? Well, you do the analysis, you go, yeah, you've got a significant collection here. Okay, well, who's gonna be, and I like to leave the be there, who's gonna be your trustee? And of course, as we all know, when we're drafting our normal family trusts, typically, you've got the settlors as your first set of trustees, and you might have children, you might have, your cousin Earl, you might have a brother, whomever it might be. You got to look and say, who do you want your trustee to be for your firearms collection? It may or may not be the same person whom you want to handle your finances. And all sexism aside, you may not want, Aunt Mabel to be charged with possessing and maintaining and keeping safe these firearms if she wants nothing to do with them or she knows nothing about them. It might be an undue burden on her. She might be a whiz at finances. She might be she might be a finance attorney, who knows, but she might not have anything to do with guns, and she might not be the person you want to be in charge of your firearms, especially with the big collection. And you're trying to get those down to, say, grandchildren or great-grandchildren who may not be old enough right now to take possession. So we don't have a distribution situation or distributory trust like we expect. We might have an administrative trust that's going to go on for 10, 15 years. Mabel may not want to have anything to do with it. Your wife may not want to have anything to do with it. My wife sure doesn't. So she may not be the person you want for your firearms. Next, we have to look at firearms themselves. And as we're going to get into in a little bit, firearms and firearms law is very complicated. The trustee whom you pick may not be able to serve as your trustee either, okay? So who can't be your trustee for firearms? Well, obviously anybody subject to a protective order, right? Subject to any kind of restraining order, protective order, temporary or permanent. You have a domestic violence charge pending. No, you cannot be a trustee of a firearms trust, or arguably you can't even be the trustee of a standard family trust with a firearm in it, because you, again, have to be able to take possession of that firearm and maintain that firearm and keep it safe. And of course, anybody who's been convicted of a felony, that's a no-brainer. Any kind of felony we're talking about. So for those of you not in the know when it comes to criminal defense law, essentially, basically anybody who has been sentenced to more than a year in state prison or local jail is going to be a felony for the most part. We do have to be careful of what's called a wobbler offense. And these are offenses that could go either way, as the name would imply. Could be a misdemeanor, could be a felony. And so you have to look very carefully at the plea agreement or the sentencing documents to see whether or not the offense is in fact a felony, straight up, or a wobbler. So for example, a crime like 245, assault with a deadly weapon, can be filed as a misdemeanor or filed as a felony. And so with that, before you knock that person out of the running, you have to kind of take a look at it and say, can that person serve? They may not know. And I've had that circumstance where, Uncle Cletus says, yo, sure, I'd be happy to have the firearms. And you say, well, do you have any criminal past? Well, yeah, sure, there was just that one time, I smacked a guy or whatever it might be. And it may seem harmless enough, but there are a number of offenses that will basically disqualify him or her from serving. And it's not just felonies. And this is, don't worry about writing stuff down frantically here, folks. I'm going to have this as a handout for you guys to take with you, along with your goodie bags of prizes today. And this is basically a list of all the different offenses that a person can commit, be it felony or, in this case, even misdemeanors, that will disqualify that person from serving as a trustee of a firearms trust or any trust with a firearm in it, because you can't have firearms. And so you see here, there's a whole huge list, and the list just goes on and on and on. And a lot of times it's obvious. A lot of times it's axiomatic. Shooting in an unoccupied aircraft or inhabited dwelling or something seems pretty straightforward. But you also get some of these ones that are somewhat banal. drawing or exhibiting a deadly weapon, including a firearm, in a rude or threatening manner. You see this one sometimes when somebody wears a buck knife on their belt, and they have a jacket or something over it, and they get into an argument, and person one says to the guy with the knife, "Hey, I'm going to step outside and beat the hell out of you." And person two, pulls his jacket back and says, "I don't think so. I'm going to cut you up and kill you." Well, that could be deemed to be drawing or exhibiting a deadly weapon in a rude or threatening manner, be it a firearm or a knife or a club or whatever. So some of these things are somewhat difficult to determine. Some of them are obvious, but discharging a firearm in a grossly negligent manner. You're cleaning your firearm and you screw it up and you accidentally discharge the firearm. Well, if it hits somebody, hurts somebody, damages property, starts a fire, guess what? You could be barred from having firearms for up to 10 years in California under any one of these misdemeanor charges. You got to kind of be aware of this kind of thing. And even basic things like assault, battery, you see those ones there, they're common. I mean, you see assault and battery charges kind of tossed out like heads nowadays. It's very common, and we see that. So be aware of that. So when you're asking, when you're doing a little bit of voir dire on your prospective trustees, you got to ask. I mean, what have you been convicted of? I mean, sure, DUI, fine, but again, an assault, a battery, whatever. It's 10 years in California that person cannot have firearms or ammunition for that matter. So the list just continues to go on and on and on, and you can see that we have this huge list. And of course, it's worth noting that things like addiction to alcohol or drugs also disqualifies the person from owning, using, possessing firearms. So that's a problem. You got to think about that kind of issue. Hopefully your trustee, hopefully your settlors are going to have a good sense of, what Uncle Cletus is about. No, he's a terminal drunk and we don't want him in charge of our personal finances, much less firearms. But again, you may not know that. We want to make sure that we think about these things. Okay, so in your trusts, typically, I will have a clause very similar to this in my trust, be it a gun trust or be it a standard family trust, which is basically in the section regarding trustees. Sometimes we can put it in the sections regarding powers of the trustees, just somewhere in there. It's a CYA measure nonetheless. Put it in there. The person who is going to be nominated and would be willing to serve as a trustee must not have been convicted of a felony, have a restraining order, et cetera, et cetera. And here's another little dodge on this one, guys. California and federal law are not the same when it comes to firearms. So number 4 becomes real important in the circumstance of domestic violence. They're very, very common. We've seen a huge spike in domestic violence charges because of the pandemic. You put husbands and wives under stressful situations, living at home for long periods of time, stuff happens. And we're seeing a huge uptick in domestic violence charges, huge uptick in domestic violence convictions. California says if you've been convicted of domestic violence, whether or not you do jail time, whether or not anyone's even injured, okay, it could be something as simple as pushing the wife or pushing the husband or throwing a cell phone at them, or whatever. If you're convicted, then no firearms for you in California for 10 years. The federal law says, not so fast. The Lautenberg Amendment under the federal law says, no, that's lifetime. You may not ever get your firearms rights back short of a full presidential pardon under the federal law. So you get this weird dichotomy because in California, you can own, use, possess dangerous, deadly weapons, ammunition, whatever you'd like after your 10 years has elapsed. The federal law says no. Well, where we get the confluence of those two things is going in to buy a gun, for example. You go into your local gun store and say, hey, I'd like to buy that gun. And they, when they do the background check, the 10-day background check and the weight and all that, well, the California, so that system is going to go into 2 different systems. They're going to have the state and the federal. So the ATF and the Cal DOJ. Cal DOJ is going to come back and say, yep, he's clean. Go ahead and give him the gun. They're going to go to the FBI. They're going to go to the ATF databases, and they're going to see that domestic violence charge from, 19 whatever. And they're going to go, no, you can't buy that firearm. So you get this weird dichotomy. California says I can own, use, possess it. I just can't buy it. Okay. Well, how does a person like that get a firearm? We're going to deal with that a little bit more in the nuts and bolts of it, but it can be done. But nevertheless, depending on your risk aversion, you may not want to have anyone who's ever had a domestic violence charge of any sort because they could run into that federal problem. So you're going to see the handout. We're going to have a bunch of different cases there where you can see where you can and can't get it. So in the powers of the trustee, again, this firearms are, again, a little different than cups and chairs and tables and stock and whatever you might take possession of as a trustee. I typically put provisions like this into my gun trusts if I know there's going to be a big collection. Why? Because your first trustee is always going to be the settlor and or his wife, jointly or individually. And that person's going to want to do what people do with firearms. They're going to want to take them out. They're going to want to shoot them. They're going to want to display them. They're going to want to do whatever the heck it is they're going to want to do. You need to put that, you need to enumerate that as a power of the trustee. Something next of estate property, right? Typically, we will say that the trustee has the right to, take, say, a house out of the trust for the purposes of selling, or take the house out of the trust for the purposes of refinancing or whatever. But when it comes to financing, and when it comes to firearms, you're going to want to be able to say, hey, he can take them out, he can fire them, he can save them, he can sell them, he can change them out, he can do whatever. So think about something along these lines that allows your trustee or trustees the power to do whatever. Purchase, sell, transfer, register. Now, this is another critical one. We get into California again, as well. We'll get into a little bit. California has had now four separate assault weapons bills and 4 separate assault weapons bans. What that means is that they have, in 4 separate bites of the apple, made differing firearms assault weapons in different strokes. And so a gun, say, purchased in 2002 may not be legal in 2015, 2017, 2020. A gun that was purchased perfectly legally at one stage will suddenly become a felony stick. And we run into this all the time, especially in the context of estates. You ask the widow, hey, does he have anything illegal? Does he have a fire? Does he have an assault weapon? Widow says, well, no, everything was legally purchased. He went down to the gun store. I was there with him. So obviously it was legal for him to buy in the year 2000. Surely it's legal for him to have it today. No. In fact, it's a felony stick, depending on how you configure that. So for your trustees, it is of paramount importance that you give them the ability to sell, transfer, and register these firearms, because down the road, you may need to do that. The trustee, the subsequent trustees may need to, in a future ban, need to register that in order to keep that gun in the family or in the estate. So think about powers. Revocation of the trust. Now, this is primarily for NFA purposes, but as we all know, most trusts are revocable and can be done so on a whim. However, we want to put a paragraph, we want to put a clause in there that says, hey, you've got to take care of the firearms in there first. So in the context of NFA firearms, if you've got a suppressor or a machine gun or something, you should not, under any circumstances, close up and complete that trust without getting rid of the firearm in it. Because now you potentially have that firearm in possession without the NFA trust backing it. And even though nowadays you don't need one to have, you needed it at the time you bought it. So think about the revocation of trust. You might just want to have language in there to that effect. All right, so now we're talking about in the context of trust and estate management, all right? You've got the widow that comes to you and says, look, father, grandfather, husband, somebody died. He's got bang sticks. They go bang. I don't know what the hell they are. No matter what you do, no matter how we ask it, they just don't know. They may not be involved in it, okay? Maybe the kids, maybe the grandkids. They don't know. They have no idea what grandfather was up to. And frankly, because of the Byzantine nature of California firearms law, frankly, nobody may know until we really, really look closely. So in the slide here, we're basically coming up with a triage here. What do you do, all right? You may have a gun safe like you see here on the right. Ask them if they have the combination to it. Sometimes they do, sometimes they don't. If they have it, that's great. You can get in there, you can look at the guns. If they don't have a combination, which is often the case, then you're gonna have to get a safe cracker in there. You're gonna have to get a locksmith in there to essentially drill the safe and get into it. And once you do, what you're going to want to do is ask the widow, ask whomever it is, to do the triage. Look for what we call the on-duty weapons, okay? These are loaded firearms that are typically kept in the house, under beds, in closets, behind the duvet, whatever. Look for them. Unload them if they know how, or ask for help in doing so. We don't want anybody hurt. Firearms are a tool like any other. You got to know how to handle it. And in so many cases of, for example, semi-automatic firearms, people pull the magazine out of the bottom of the firearm and say, oh, safe now. And they forget that there's a round in the chamber, and unfortunate incidents occur. So always ask them to look for those on-duty weapons, unload them, or ask for help. Okay, there's a lot of folks out there who know how to do this stuff. It doesn't have to be a firearms attorney like myself, but nevertheless, get everything safe. Next, do a little triage, get the make, model, and serial number of each and every firearm, put it on a spreadsheet. Sometimes the make and model is a little bit dicey for people who don't know guns, but the serial number certainly is easy enough. It's printed, should be printed on every firearm. And for the most part, simply taking pictures of all these firearms is easy enough. If you guys ever have an estate out there and it has guns involved, you have any questions, you can always go to me and say, hey, David, can you see some pictures here? Show me what I got here. I'll be able to tell you if it's A, illegal, B, valuable, or C, loaded. So we look for that stuff. And the things we're looking for assault weapons. That's a loaded term because nobody really knows what that term means, least of all the legislature and least of all police. But nevertheless, they're out there. We need to see if there are any assault weapons in there. You can't tell by looking at them. A lot of times people will look at it and say, hey, that's an AR-15. That's an assault weapon. No, not necessarily. It could be a registered assault rifle. It could be an assault rifle registered in the year 2000 or 1988 or any one of the subsequent bans. So we need to know that. Will the widow or widower know? Maybe, maybe not. We need to look at it. All right, we're looking for 50 cal BMG. That's a caliber, 50 caliber Browning machine gun caliber. They were banned back in the 80s, and they're banned by caliber. And so if you see such a weapon and it's a rifle caliber weapon, chances are it's illegal or it's registered. We need to know. NFA items, you're probably not going to see too many of those. Okay, these are those fun-looking things we showed you early on. Your machine guns, your field artillery, whatever. But again, sometimes it's deceptive. An AK-47 that's fully automatic looks absolutely identical to an AK-47 that's semi-automatic. Almost no way to know without disassembling the firearm and functioning it, making it cycle and see what it's doing. Off-roster pistols. This is another one we'll get into a little bit. California, back in about 2009, closed this roster. We have this roster of safe handguns. California decided that they don't want unsafe handguns floating around in the state, except, of course, in the hands of police officers who are perfectly capable of buying them under law. But you and I don't get to purchase unsafe handguns. These guns have to be on this roster. There's a whole list of these firearms. It's about 650 to 700 firearms and falling. Every year, the list goes down and down and down. But nevertheless, they have to be handled differently than regular firearms in terms of their transfer. So we'll talk about that. Then lastly, rare, historic, unique, whatever. We're looking for value, right? We're always looking to see what's going on in the estate. Do they have the Mona Lisa in their bathroom? Do they have Blue Boy in their closet? Well, no. But do they have, an 1894 Winchester that was, used by Gene Autry in all of his movies? Maybe, that kind of stuff. So we're looking for that kind of stuff. And lastly is ammunition. Ammunition, also known as prison cigarettes. And that's, again, by definition. They're prison cigarettes because they hold their value. They're traded. They're absolutely like gold bullion. We in fact, in the gun world, call them investing in, quote, heavy metals. And that's, steel, brass, copper, and lead. They're valuable. They hold their value, and they go up significantly. Ammunition prices have gone up 100% in the last year or two. 100%. So, grandfather's collection of, 2,000 or 3,000 rounds of ammunition that, you might have just thrown away or sent to the dump or whatever many years back might be very valuable right now. We need to look at those prison cigarettes and see what they might have. Lastly, California banned the transfer of ammunition between parties without the use of an FFL. That's a federal firearms licensed dealer. So you can't go and hand a pack of 22 rifle ammunition to your son and say, go have fun, son, go shoot for the day. Or to your brother-in-law or whatever. You cannot just give them to them. And as an estate manager, as a trust administrator, we've got to deal with that. Now, again, this is the black letter law, all right? You come to me and say, David, what's the black letter law on ammunition? I'm going to tell you, it's just like a gun. You're going to have to go through a firearms dealer to transfer that ammunition. And the recipient thereof must go through a background check, believe it or not, to buy ammunition or to transfer ammunition. So if the widow says, I don't want any of this ammunition in my house, I want to give it to my son who's 54 or whatever, and he lives down the street. Well, you have to tell the widow, sorry, Widow Smith, you cannot give that ammunition to your son, your son-in-law, your brother, whatever it might be, because it's against California law. That's the black letter law. And then now we get into self-help. Who knows? Who does, what they don't know doesn't hurt them. If that ammunition is swept up into the estate, like all the rest of the chairs and tables and cups and plates and bowls, and you distribute it throughout, who's going to know? Who's going to find out? Well, between you, me, and the lamppost, probably nobody. But I've given you the black letter law on that. Don't just transfer that ammunition. Don't put an ad up on Craigslist, for example. Even if you could, Craigslist doesn't allow you to sell ammunition. But Gunbroker, for example, is the site right now for, it's kind of the eBay for guns. Don't put an ad up on Gunbroker, whatever. You can take it to an FFL and consign it. They can sell it for the widow or the widower, but don't just hand it out down the street lest you get into trouble. So we're talking a lot about assault weapons, right? And these assault weapons come in all shapes and sizes. So, Matt,
we do have a question. Going back.
Great.
Would you advise a client to call their local police department with assistance in making sure all firearms are rendered safe?
That is a fantastic question. Do not, under any circumstances, ever contact law enforcement for whatever reason. They are absolutely hopeless when it comes to firearms. And the higher up you go, the worse it gets. If you contact ATF or you contact Cal DOJ and you ask for an opinion, it's much like the DMV. You call back 3 times, you'll get 4 opinions. More importantly, if you ask and they come out and they check it, and it turns out to be something that is configured illegally, although it could be configured or reconfigured to pass muster, you're going to lose that valuable item. So no, do not contact the police. There's no guarantee they know what the hell they're doing, or if they're even going to come out. And by example, I'm going to give you, back in 1988, I was living with my parents, still in high school, collecting firearms. My father had an M1 carbine, like you'll see here in the picture in the upper left-hand corner. That's an M1 carbine used in the Second World War. It has a detachable magazine, 15 to 20 rounds, fires a 30 caliber carbine round. My father, who was a Marine Corps veteran, taught me to shoot very early, had one of these things fully loaded up in the closet, and it was hidden under the duvet cover. I used that literally. He had it hidden up in the closet, fully loaded for when all hell broke loose. Well, one day the house was broken into. It was burglarized, and the house was tossed, and a number of different things were stolen, including that firearm. Okay, well, we had the serial number, as any good firearms owner is apt to do. We had the serial number. We knew the gun. We had to make model, serial number, and a spreadsheet. Which of course at that time wasn't a spreadsheet, it was just a sheet of paper, but nevertheless, and we told the police, hey, that gun's missing. Well, believe it or not, about 2 or 3 weeks later, that firearm was recovered by the Westminster Police Department, small local police department here in Orange County. My mother got the call. My mother knows nothing about firearms, although she did buy the gun for my father for Christmas in 1985. That's just the kind of family I come from. But anyway, she was given the call. Hey, ma'am, we got your firearm here along with a bunch of other stuff we recovered from the burglary. Can you come down and get it? I was in high school. My father was working. So my mom, she being a trooper, sure, she goes on down there. She goes to the Westminster Police Department. She signs for the firearm. She signs for all the other knickknacks and trinkets that were recovered. The officers very kindly took all the junk and put it in the car in her trunk for her. And I get home after high school, and I come, and mom says, hey, Dave, the firearms, or one of the firearms came back. I said, that's wonderful. Let me go look. So she left it in the trunk of the car. I go out to the trunk of the car. I look down, and I see that firearm is exactly the same condition as my father left it. That means fully loaded, round in the chamber, trigger safety off, and fully loaded magazine. It came back to my mother that way. That means some law enforcement officer picked up that firearm from wherever. They must have looked at it. They must have had it. They indexed it. They found the legal owner, whatever. They gave it to my mother, who didn't know a darn thing about firearms, put it in the trunk for her, and off she went with a fully loaded rifle in the trunk of her car. And of course, the first thing that I did when I got a hold of it is obviously pull the magazine and racked it and cleared the round that was in the chamber. But so the moral of the story is police don't know anything about firearms. They carry firearms because they're tools. They're required to do so. Many officers are very good with firearms. Many officers, including SWAT officers and people like that, are former military, and they're every bit as good with firearms as I am. Absolutely fine. You just don't know whom you're going to get. You might get, you might get, anybody from Sergeant York to Barney Fife coming out to look at your firearms. So you just don't know what you're going to get. So no, don't call the law enforcement, call me, call an attorney, call a firearms attorney, call a gun guy, call anyone down, anybody who knows what's going on, so we can at least clear the weapons for you. But when it comes to deciding what an assault weapon is or whether it's legal, you really are going to need somebody whose specialty crosses from firearms into law, because trying to keep track of this stuff is absolutely crazy, and the laws are Byzantine. So don't call the cops, much less the ATF or anybody else. Call somebody though. Don't touch them if you don't know what you're doing, because you touched the wrong thing the wrong way and it could ruin your whole day. So looking here at assault weapons, whenever I do a talk on firearms, as I'm called upon to do, I like to play this little game, especially if people are in the audience. So I'm going to ask you guys to go to your keyboards for a moment or two here. Take a look at these firearms. You've got an M1 carbine, you got a 1919 A4, you got a AK-47, you got a good old M1 Garand from the Second World War.
Hey, David,
an
sorry to
AR-15,
interrupt.
a couple of different AR-15s.
David, sorry to interrupt.
I hear a
but
voice.
They can't access anything. So
No voice.
no voice, no typing, nothing. So you can ask them,
Nothing. Okay.
say something in the chat if you'd like. But they
Sure.
don't
I mean,
access.
you guys
Sorry.
can take your guesses. You can ask yourselves, take the challenge. Can you guys figure out which are the assault weapons? The long and the short of it is, let's see, we got a question. No, that's a great question. I guess I can type the answer. No. But anyway, normally in a real live room, it works a whole lot better. The long and the short of it is, folks, it's a trick question. You cannot answer the question. Why? Because you can't tell what the cycling or the magazine release capabilities of the firearm are by looking at it. Some of them I can look at and tell you whether they are not. Generally, sometimes you cannot. So going over this sort of thing, we talked about the M1 Garand down on the bottom right-hand corner, bottom left-hand corner here. That is a semi-automatic rifle with an internal magazine carrying 8 rounds of 30-06 ammunition with a long, scary bayonet on it. That is not an assault weapon, even though it's the weapon that won the Second World War. The upper left, the M1 carbine, also not an assault rifle as configured, although could potentially be illegal depending on the amount of rounds you have in the magazine. The big scary machine gun in the top center here, the the M1919A4. Again, assuming it's not fully automatic, which would make it illegal in California for, ab initio, could be legal, could be not. It's not an assault weapon. On the other hand, that belt of ammunition could be a problem and could render that weapon a felony if it were sticking out of the gun in that configuration under certain circumstances, depending on whether or not the owner of that firearm had the belt of ammunition loaded up before the year 2000 or whatever. Going to the right-hand side, the AK-47 ordinarily would be illegal, but you see that little funny grip fin sticking down from the grip. That renders it a featureless rifle. And in California, that's an important variation. That's an important factor here. That basically turns that AK-47 into basically the same rifle under the eyes of the law as the M1 carbine over on the left-hand side. So the long and short of it is, after we get done humiliating people who like to answer these kind of questions in a big room, is you just don't know. You just can't tell what the assault weapon is and is not. So get out there, be sure to ask for help. California has banned assault weapons in 4 different iterations. They started in 1988 following the Stockton shooting up in Northern California, where some lunatic took an AK-47 to a schoolyard full of children. In 1988, California took the first stab at it. They banned assault weapons, quote unquote, by name. They didn't, the legislature didn't know a damn thing about firearms, and they knew it. So all that they did is they basically took the names. They said, we're going to ban AK-47s. We're going to ban AR-15s. We're going to ban HK-93s and 91s. There you go. Problem solved. Well, the industry being what it is, if not creative and resourceful, went, oh, okay, you banned the AK-47, great. We're not going to sell that firearm in California anymore. We're going to sell an exact duplicate of that firearm, now called the AK-47 Sporter or the AK-46. Well, guess what? It's the same bloody handgun. They just changed the name. So California, again, oh, they got wise. So then they went back in the year 2000 and they banned assault weapons again, but this time by feature. Now they looked at it and said, okay, what makes a rifle an assault rifle versus a featureless rifle? They went by these features, and they're looking for things like pistol grips, bayonet lugs, flash hiders, high capacity magazines, magazines that can be dropped by the push of a button. So they went through and they tried to ban these things by their features. Also in 2000, they banned high capacity magazines. So again, when you guys are looking at an estate, grandma, grandpa, whomever might have a whole stack of magazines, okay? These are simply, you know, the things that you put the bullets into, right? Those could be magazines. Same thing like in the last slide we saw, that belt of ammunition on that machine gun, that's a defeating device. That's a magazine for the purposes of the law. If that magazine didn't exist before the year 2000, it is illegal to import it, sell it, transfer it. Keep aware of that when you're doing your estates and you're managing these estates. You can't just hand these things out. You're violating the law, and we've got it here for you in Penal Code 323.10 alpha. So then, after the year 2000, it's been this cat and mouse game. The state said, fine, we're going to ban these assault weapons by feature, right? So you can't have pistol grips, and you can't have flash suppressors. All right. Guess what? The industry changed, and we started changing up how we configure them. It's the same rifle, had the same lethality, had the same number of, you know, the cyclic rate and everything else. We just changed certain things out, and we fooled the state again. So then in 2017, they got rid of a whole class of firearms that had certain bullet buttons on them. These were little devices that we would put on the button to remove the magazine. And so it would put a little shroud over it so you couldn't hit it with your finger, but you could release that magazine with the tip of a button, tip of a bullet. And we call them bullet buttons. And that legalized that same exact weapon to use for shooters and competitors and whatever. And so again, California was thwarted. And then in 2017, again, they instituted the background check for ammunition. So same problem. You guys got to be careful of what you've got in your estates. You might have, I mean, typically if you have handguns, you have rifles, you're going to have all these other accoutrements. You're going to have magazines. You're going to have, you know, magazine feeding, ammunition feeding devices like belts. You're going to have ammunition. You're going to have all these things. So be careful. Know what's in the estate. And of course, again, yeah, you might even have these NFA items, which are unlikely, but should you encounter them, you really want to steer clear and know what you're doing. All right, so how to transfer these firearms? So you know, father dies, wife isn't interested, adult child now comes down the line, or other family member. What are we going to do with these things? How are we going to how are we going to counsel our client, the trustee, or the successor trustee, to handle this? Well, we all know what to do with houses, and we know what to do with stocks, and we know what to do with bonds. We don't know what to do with firearms. Well, we have all the California firearms transfer laws to deal with, okay? California firearms laws is different depending on whom you are. We deal with this line of consanguinity. I frankly just threw that in there because I love the sound of the word, consanguinity, but it does have a bearing here, okay? In California, if both the transferor and the transferee are both in the state of California and are residents of the state of California, if they are in the line of consanguinity, being parent, child, grandparent, up and down the chain, not side to side, brother, sister, cousins, whatever, it's important to know where we are. But if dad dies, mom has the pistol, mom has the rifle, and son, who's otherwise eligible to have that firearm, wants that firearm, okay? Mom has a couple of options. She can simply give that firearm to Junior. Say, son, your dad wanted you to have this. And again, provided she's been properly counseled and the son is otherwise eligible, all the son need do is to get his a firearm safety certificate. This is a certificate, much like taking the driver's test for firearms. Everyone in California who is going to receive a firearm must have one. They can be gotten at any gun store. It's $25. It's about 25 questions. Generally, if you can fog a mirror and think logically, you can pass the test and you can get your certificate. It's good for 5 years. So mother goes to son, says, here, son, just have this. Have your father's firearms collection. No need to go through an FFL, okay? If both the transferor and the transferee are both California residents in California and they are in that line up and down, father, son, grandfather, okay? Mother may not give the firearms to her nephew, to her stepson, to anybody else, only up and down that line. If they are not in that line, the transfer must go through the FFL. That's basically both a state and a federal requirement. If mom is in California, but she wants to give the firearms or the firearm collection to cousin Jimmy, and he's in Poughkeepsie, federal firearms law requires that mom take that firearm and either send it directly to the firearms dealer in Poughkeepsie, or depending on what the firearms dealer in Poughkeepsie wants, that mom might actually have to take the firearm to her local firearms dealer here, let's say Buena Park or San Francisco, and say, here, will you please transfer this firearm to the other FFL? Because many FFLs will not receive firearms from individuals, but only from other dealers. Nevertheless, once you sort that out, mom gives the firearm or sends the firearm, whether directly or indirectly, to the firearms dealer in Poughkeepsie, and that person then will transfer the firearm to the recipient. And that's whenever you go interstate, okay? And again, interstate requires the FFL. You can go interstate interfamilial, or you can go interstate perfect stranger. Maybe in the will, maybe in the trust, father, grandfather said, get that firearms collection to my old war buddy, Stan. Okay, no familial connection whatsoever. But in order to get that firearm collection or that firearm to Stan, you're gonna have to go through an FFL. Recipient has to have that firearm safety certificate. So be aware of that. Age issues. In California, generally to buy a long gun, you have to be 18 years old. They're looking to move that up to 21 now. 21 for pistols. That's general rule of thumb. But that does not apply to the acquisition by law or op law. Doesn't require that age. So if parents, grandparents, whatever, want to transfer handguns to some grandchild or child who is, illegal for that person to buy it, they're 18, 19, whatever, they can legally receive the handguns. This is an odd little quirk, but you should be aware of it because a lot of times you get people who are 18, 19, 20, they want to get dad's firearm. They want to get his pistol. They want to get his, whatever. And there you go. And of course, it only gets more complicated if Sonny Boy has a domestic violence charge or has some other kind of crime in his background. Now you as the, attorney for the trustee now has to kind of look at that and go, God, what am I going to do now? But you look at these things, or you contact me, you contact a firearms attorney. We can help you through the nuts and bolts of these things. So as we talked about, we got this inline transfer here. If you're in California, you're going California to California, generally you don't have to deal with the FFL. You also don't have to deal with a bunch of the other things that California law throws in the path of a gun buyer. Typically, if you want to go buy a handgun, you want to go buy any gun really in the state of California, you're going to have a 10-day waiting period regardless. Even if you have a CCW license, even if you're even if you're a CCW holder, or that's a carry concealed weapons permit holder to you and me, or if you might have a dozen guns in the car legally, you've got to wait 10 days under the state's laws because you might do something crazy with that 31st gun. So you got to wait 10-day period. We also have what's called a 1 in 30. In California, you're only allowed to buy one handgun in 30 days, also applying to rifles soon. So you can't just go to the gun shop and do the Rodney Dangerfield like he did in Caddyshack. Give me a dozen of those and 15 of those and 20 of those. You get one. You can buy one handgun. Or actually, you can convert. You can buy more than one gun, but you have to do it in one dose in one session, in 30 days. And also the under 18, 21 thing here. So you don't have to deal with all that. If you're dealing with this inline transfer, it makes things a little bit easier. Also, you're going to want to consult with a firearms law attorney, but at least let the recipient know that under California law, you have to file what's called the Hart-Law form. Look for it in your packet of forms, gang. I've got it there. It's online. It's a fill out form kind of thing. If mom goes to son and son says, thank you, mom, dad always, wanted me to have this pistol, that's great. Son then is going to have to file this Hart-Law form with the Cal DOJ to be within the letter of the law. It's a $19 fee. He can put as many guns on there as he wants. If the whole bloody collection is there, he can Hart-Law the whole bloody collection, whether it be one gun or 10 or whatever. But they does technically have to file this Hart-Law form. So be aware of it. Typically, when I do a firearms trust, if I do an NFA trust or I do a firearms law trust, I will provide those forms, at least the latest iteration of those forms, to the settlor in the packet of documents. I do gun trust all over the state. They don't have to come down and see me. They can do it, obviously over the internet or whatever, and I can PDF them the forms. They print them, they notarize them, and I usually direct them to print out those other forms, be it the Hart-Law form or the Volreg form, all these other, gun-related forms. Put them in the binder along with the list of the firearms and the different trusts, so that the next trustee in line has everything they need to at least freak them out and at least ask certain questions and maybe scare them into my office so that they know what's going on, and they know what's going on in terms of the different firearms. Now, if they're out of state, as I said, federal law applies, not just state law. And it becomes very questionable here. You got to be very careful, because if grandfather or father, let's say, bought what was an AR-15 in the year 2000, and it was legal for them to buy it in the year 2000, and he stuck it under the bed, and it's been sitting there for 20 years gathering dust, it is now a felony to possess that firearm, even for father, okay, because he didn't register it. Or maybe he did, maybe he didn't, but that's a felony potentially, okay? But you got this firearm, and the widow comes into you and says, Mr. and Mrs. Attorney, I got this very valuable firearm. And it is, an AR-15 pre-ban might be $2,000, $2,500. Maybe she needs the money. What am I supposed to do with this thing? I don't want to just give it to the police. I don't want to have it cut up. I don't want to have it destroyed, whatever. What do I do? Well, you can sell that out of state. You can consign it to a firearms dealer here in California, but that firearms dealer has to have not only the FFL license, but they have to have the assault weapons license over and above that. Most don't have that. So the widow then is left with transferring that firearm out of state. California law allows for the trustee of the trust or the executor of the trust 90 days to deal with this stuff. So don't panic if they come into your office with a briefcase full of guns, right? They got 90 days to sort it all out. Even if it's an assault weapon, okay, you're fine. It's not like it's going to be crack cocaine and they're afraid they're going to have to throw it into the nearest lake. Tell them to relax. They got 90 days to deal with it. Call me. Call a firearms attorney. Have us sort it out for them. If it's legal for them to sell in the state, we can tell them so. If it's not legal for them to sell in the state, fine. They can put it on Gun Broker. They can send it to a federal firearms licensed dealer in Arizona. That guy can sell it to anybody who walks in off the street and can fog a mirror. And thus they can maintain the value. So know where those guns are going. Okay, you got to analyze the trust. You got to analyze the will. Where are those guns going? Are they going in state? Are they going out of state? Whom are they going to? So be careful. Same thing with 50 cal and high capacity magazine. All of those things can go out of state. So when in doubt, if nothing that I told you today registers or sticks, just know you can always sell the stuff and get it out of California and go to a free state. Okay, so get it to Arizona, get it to Nevada, get it somewhere safe. You can always sell it and you'll be fine. So that's the absolute takeaway. Let's see here. All right, we got a question here. What if one or two of the guns, pistols, rifles in the collection are registered and the other 10 or 12 are not? What does the trustee need to do, providing the powers necessary are in the trust? Great. Okay, registration. Now, registration is a loaded word. A lot of people use that word in a lay term. I get this all the time. Guy walks in and says, hey, I got this AR-15. I said, did you register it? He says, well, sure I did. I bought it in the year 2010 when it was perfectly legal for me to do it. Didn't the state keep track of who owns that gun? And didn't I have to go through a background check? And isn't it under my name? I say, yes, yes, yes. That's all true. Every one of those things are true. Did you register it in the year 2016 when they made that gun illegal? Oh, well, no, I didn't. Well, guess what? You got a felony stick there. Okay, so registering means registering it with California Department of Justice through the CFARS system, and it's an involved process. Maybe he did, maybe he didn't. Typically, if I ask the person, did you go through CFARS? Did you take pictures? Did you get a letter back from the Cal DOJ saying you have registered this firearm as an assault weapon? If the answer is yes, then I know it's registered. That means he cannot transfer that rifle in any configuration that it's been registered to anybody else, okay? Unfortunately, in that context, if it's registered, you got two options. It goes in the grave with grandfather, or it leaves the state, or it changes its configuration. That means putting a pistol grip modifier on there, reconfiguring it. That's what I do. People come to me all the time. David, configure this gun so I can keep it under the applicable laws. Okay, I can do that. So you call your friendly firearms attorney and we look at it and we say, well, you know, maybe you can fix it, maybe you can't. So for example, in 1988, the state banned the, let's say the HK Heckler & Koch HK-94 rifle. Okay, it's stamped right on the receiver, HK-94. That gun's banned by name. You can't change it. I don't care what you put on it, what you take off it. That lower, that part that has the signature on it, that has that stamp on there, you can't, it's done. You can strip it, you can take off all the other parts, but the part that's registered, the part that has the serial number on it is toast. You got to get rid of it, or sell it out of state. Now, if some are registered, some are not, you're stuck. You can contact the Cal DOJ and you can ask them. The problem is that the first two registration iterations were done prior to the widespread use of the internet. So in 1988, when I was 18 years old, I took my collection, my father's collection of what would then become assault weapons. I was required to take those guns in my hands down to the local police station to have them fill out the form, look at the firearm, take down the serial number, and send it into the DOJ for me. So you can imagine in 1988, here was this 18-year-old kid. I wasn't an attorney, I was a high school kid with maybe a dozen assault weapons or soon to be assault weapons, AK-47s, Uzis, Thompson submachine guns, just like you saw in the pictures. I carried all that stuff into the police station. Hi, I'm here to register all these. Can you imagine what would happen today if that happened? But nevertheless, that's what we did in 1988. Those records are notoriously spotty. They are largely gone. So in criminal cases where we have defended people regarding those issues, it has come to light that the ATF, and rather the DOJ, cannot confirm those records. You won't ever know. Same thing with regards to the ban in the year 2000. That also was done on paper. So the only registration that is currently accurate are the ones that were done in the year 2016, and there's another one coming in 2021. So yes, otherwise you're kind of stuck. You're going to have to, unless you can find the paperwork, you're going to have to assume they're not registered, and we're going to have to reconfigure them or get them out of the state. So that's what you do. Question. What if the value of the gun collection is high? Yes, $300,000, etc. Should you transfer title to the trust properly? Concerns are by just listing the guns on a schedule. Yes, absolutely so. You do have that issue. Now, I've not run into too many $300,000 collections, but yes, we can easily get over $50,000 for sure. But of course, to get over that magic 150, yes, there's no, the problem you're going to run into is transferring title. Yes, you could conceivably do that, but the problem is the trust can't have that title. You need another human. So what you could conceivably do in that circumstance, Mona, is you could go ahead and do the Hart-Law form and have it outlawed to the other family member. Okay, assuming your trustee is a family member and otherwise, again, eligible to receive those firearms, you could do that. The problem is most gun trusts are inter vivos and they are revocable. And the father, whomever, the settlor is usually not willing to lose control of those firearms. So it would be akin to doing an irrevocable trust very few people are willing to put their house in an irrevocable trust, notwithstanding, debt collection issues or, something along those lines. So typically there is no readily available registration source other than doing the Hart-Law form and sending it into Cal DOJ. But the problem you're going to run into in there is you're going to have a complete evaluation of the collection. You're going to have to make sure that you're not setting your client up for a felony charge, because again, if dad bought that perfectly legal, firearm in the year 2000 or 2002 or 2010, it could have been made illegal in later iterations of the assault weapons laws. And you could be committing malpractice by telling that person, okay, I need you to go ahead and file that and transfer all those firearms now by operation of law to your next trustee. First, your trustee could have a problem, as we talked about, in terms of the ability to have firearms. But secondly, you could be setting yourself up for malpractice because you've now told them to violate criminal law by transferring those firearms. So if it's an assault weapon, be it registered or unregistered, you cannot transfer that gun in that configuration. So be very careful with that. Just even though it's valuable, you still may have a problem there. You're always better off documenting it, getting an estimate, for example, from a firearms attorney or a gun shop or somebody like that, an appraiser, to document the value. And then if necessary, and if it's completely transferable and you can do it, sure, you could conceivably do the Hart-Law form or Vol-Reg form, but 9 times out of 10, you're going to have some problem with some of the guns, unless they're old Western kind of guns or something along those lines. So usually the risk is not worth the trade-off. I know you have that concern with the 850 petition or even probate, but again, the best way to avoid probate, self-help, right? If you had the Mona Lisa sitting on the wall and it goes right to the next family person, who's going to know? Is the state going to know? It's only really where you get into a fight where somebody is going to start, complaining. That's where probate is obviously a forced petition, a probate petition is filed. All right, then the jig may be up. So yeah, you have to be very careful. You have to look very carefully at that. Okay, other questions? I don't want to run over time. I want to make sure we are timely on this stuff. Any other questions? Anything else out there, gang? Matt, are we good? Are we clear? Is the board clear?
I'm not seeing any.
Great.
Let's
With
see
that, then I'm going to give you a break. We've made it in under our time, which is all I was told to do, is make sure I'm at least marginally entertaining and bring it in under time. So I think I've accomplished those two things. Keep an eye out in your mailboxes for those Hart-Law forms and those criminal forms. Just so you know, if you have any question, contact me. I'm basically David Salvin, ESQ, at gmail.com. I have a gun trust website. You can find me all over. Just Google David Salvin. I'm out there. Any questions on firearms, please let me know. I'm here for you, whatever you guys need. Let's see. We got an anonymous question. If a client needs to transfer a weapon out of state, since it's not legal in California, is it basically contacting an out-of-state FFL and shipping it there? Yes. How's that for an answer? Yes, it sure is. You do have a little bit of question. If you're going to try to drive that firearm across state lines, be careful. You don't want to be driving down the highway and let the chippies catch you with an assault weapon. But nevertheless, you can certainly ship it out of state. You can take it to your local dealer, but the problem with the local dealer is they've got to have an assault weapons permit to do that. Chances are they don't. So your best bet, put it in a big old box, take it down to Kinko's, take it down to UPS with tracking. If they ask you what's in it, you tell them machine parts. Don't tell them it's a gun. Machine parts. Off it goes. It gets to the FFL, problem solved. But yes, it is simply a matter of getting it out of the state or into the ground with grandfather. You got 2 choices. More questions.
We have one more question. I have a probate matter and listing down on INA, inventory and appraisal. How do you handle that?
Okay, so again, if you need an appraisal, I can do that. Gun appraisers do it. Gun sales guys can do it. There's auction houses that can do it for you as well. So it's just a matter of getting somebody whom both sides are okay with, essentially. The problem you run into with a certified expert, say for the courts, if I'm asked to talk about firearms law, that may not be appraisal work. So you're not going to find somebody who is a court-approved appraiser, typically, for firearms. You're usually not much of a mix there. So you might have to go off-road a little bit in that regard. But It can be done. I can do that, or any number of different firearms sellers can do that. Okay, so yeah, definitely do not, in any circumstances, contact the police about these things. That's a bad idea. All right. Oh, my contact information, that's David Salvin. My last name is spelled S as in Sam, A-L, V as in Victor, I-N, David Salvin. And you can, like I said, Google me. You can go to David Salvin, ESQ, at Gmail and shoot me emails, pictures. Best thing is send me some pictures of these guns. I'll know in 2 minutes whether or not we're dealing with something dangerous or not. And if you need me as an expert in your probates, or actually as an expert in your firearms case, if it's criminal or whatever, civil case, that's fine. I'm happy to help out. I work for folks all over the state. So look me up. My phone number, if you want to find me, is in the 949 area code. I'm here in Orange County, 949-305-6400. There you go. Any other questions, Matt? Do we got everybody?
I think we got everybody. Thank you so much, David.
Beautiful. Thank you all. You've been a wonderful audience. Be sure to tip your waitresses, try the veal, and we'll lay it out. We'll leave it. We got 10 minutes left on the clock. Anything else we need to handle, Ann?
I think we're fine. You guys
Very
are all
good.
good?
I'm going to sign off, gang. Thank you so much.
Okay.
Yep.
Okay.
Thank
Wonderful.
you.
Have a great seminar, everybody.
Thank you very, very
Bye-bye,
much.
everybody.
Dave. Thank you very much.
No problem. Happy to do it.
Okay. So Anne, I'm wondering, it looks like we have about 5 minutes ahead of schedule. How about if we reconvene then at 1:40
Okay.
instead of 1:45?
So, well, everybody, we're going to take a break, and we'll see you all at 1:40, okay?
Great. Thank you.
Very good. I thought you did a great job. I was worried about him running short, but not an issue.
That was very good.
I'll see you all soon.
Okay.
Bye, Matt.
Don't forget, we have a text, guys.
We have a what?
We can text if we need to talk.
Oh, yes, yes. Yeah. Oh, everybody's still sorry.
I'm the host. Yeah, so tomorrow I'm gonna be here around 3. For Nelson. Yeah. Is that, are they open? They are. Wow. Even 3:30, Nancy, because I'm coming from Denisha. Would that, 3:15, 3:30? Yeah, okay, I can do that.
Mm. Catherine, please
Yes,
mute
sorry,
yourself.
I'm back.
Please
Oh.
mute yourself. Thank you. Matt Toth, please mute yourself.
Where'd you guys go? No, I can't. It got me. Good afternoon, Matthew.
Good afternoon, Greg.
When do you get to host your next one?
Not sure yet.
Are you a chair of a particular committee?
Yeah, just to say we're live right now, so all 70 people are watching this conversation.
Okay.
All right. Anne? All right. And we are hopefully all back from our break and ready for our second presentation today. For those of you estate planners who wake up at 2 o'clock in the morning worrying about whether or not you correctly have the legal description on the deed that you just put in your client's trust, we are going to learn everything that estate planners need to know but are afraid to ask regarding titles and transfers of title and real property. We have three presenters today, the first being our board member, Matthew Hart, who is a certified legal specialist in estate planning and trust and probate. Matt's been practicing in Antioch for about the last 10 years, and he also teaches classes for CEB, for practicing attorneys who are thinking of taking the specialist exam. Our second presenter is Greg Herrington, and Greg's the Assistant Vice President and California State Underwriter for Fidelity National Title Group. Greg's very interesting to me because he started in this industry in 1967, and with the exception of taking 2 years off for active Navy service between, I think you said 69 and 71, he's remained in the title insurance business. Thank you for your service. In the 51 years that he's been in this industry, he served as a title officer, advisory and chief title officer for title operations and subdivision department managers, and an escrow advisor for several California title insurers. The past 35 years, he's acted as both Northern California Regional and California State Underwriter for the Fidelity National Title Group of title insurers, and that includes Chicago Title Insurance, Commonwealth Land Title Company, Fidelity National Title Insurance Company, Lawyers Title Company, and T-Court Title. A member of the California Land Title Association's Forms and Practices and legislative committees. Since 2010, Greg's also served as editor of the association's Manual of Title Practices. And last, but certainly not least, we have Steve Seto, who's a partner in Seto, Wood & Schweickert. He practices real estate, title litigation with an emphasis on representation of property owners, lenders, title insurance companies, and escrow companies in both state and federal court. Mr. Seto advises clients on various types of real estate disputes, including title insurance, escrow claims, boundary, easement disputes, lien priority determinations, partition actions, purchase and sale disputes, and quiet title actions. So, without further ado, I'll turn the program over to the three of you. Thank you.
Thank you, Catherine, and thank you, gentlemen, for joining me. About a year ago, I thought, wouldn't it be great to have a class for estate planning attorneys on what to do with transferring properties into the trust? And more importantly, a lot of us will do it, and then we start to hit different issues, and we're not sure who to talk to or how to clear it up and how it's going to work. So this whole thought started about a year ago, and it's been germinating, and it got delayed with the whole pandemic, and then it's finally come to fruition today. The conversation that you're about to hear is between Steve, myself, and Greg, and it's from three viewpoints. The first viewpoint is, when we're trying to get that deed recorded with the county recorder, what are some of the gotchas or some of the things we have to look out for? But as we know, once we get it past the county recorder, they just record it. They don't read the deed necessarily in certain areas, and they're not even rendering opinion of whether you've actually transferred title. They're just recording the document. So the next question is, have you legally transferred title to your trust? And so we'll be looking at some of these questions from that angle. And then finally, as estate planners, most of us do is trust administration. After mom and dad have died, the kids come in, they want to sell the house, they want to transfer the house to them, the different situations. From a title insurance perspective, is that house been sufficiently transferred where they can then warrant it and transfer it to the next party? Or does there need to be some court actions taken to satisfy the title insurance? And so we're kind of looking from those three different angles. And so we'll go through the different questions. Some of the questions will hit all the angles, some will only hit one angle, and we'll work our way through. But before we get into kind of the tougher things, we're going to start with a little bit of a lighter topic, if you will. And so first, Steve, I'm going to have you address, when we start to look at transferring properties in the trust, the first question we have to come up with is, are we going to use a quitclaim deed or a grant deed? And so I just want you to do a little bit of reminder from Real Property 101, if you will, that we took back in law school, the differences between the two, and then possibly some pros and cons of using one over the other in the different situations.
Sure, Matt. So the difference between a quitclaim deed and a grant deed, there are primarily two differences. Both there's an implied warranty and there's the doctrine of after acquired title, both of which only apply to a grant deed. So with a grant, with respect to a warranty, the implied warranty, whenever you grant property to a grantee, there comes with it an implied warranty that it's free and clear of any encumbrances that were made or suffered by the grantor, such as taxes or assessments or liens. That's not to say that the property is free of encumbrances, only that there's no encumbrances that the grantor suffered or caused to be made on his own behalf. And so where this really comes up is in a lot of times in sort of real property sales, where you grant deed property to somebody, and let's just say there's a lien that wasn't disclosed. As part of the grant deed, you made an implicit warranty that there would be no sort of lien there that, say your prior mortgage, that shouldn't have been on there. And so that creates liability for the grantor. With respect to a quitclaim deed, that's not the case. There's no implied warranty. What a quitclaim deed is saying is, here's title to this property to the extent I have any. I mean, there's no warranty saying that I even have that property. Secondly, there's the after acquired title doctrine. And that doctrine says that where a grantor purports to transfer property to a grantee, but doesn't actually own that property, if that property later comes into the grantor's possession and control, then that inures to the benefit of the grantee by operation of law. So for example, Matt, if I own 75% of a piece of property, sorry, I try to transfer a property to you, say my house, and it turns out I only own 75% and my brother owns 25%, then when I grant deed it to you, you would get the 75% interest, and my brother would keep the 25. But then if my brother then later transferred that 25% interest to me by operation of law in the after acquired title doctrine, then that property would go to you. That's not the case with a quitclaim deed. In that case, then the property would belong 75% to you and 25% to me. And so to answer your question about what should deed planners use, well, assume the goal is for your client to get all the property he or she owns into the trust, and then you really want to use a grant deed rather than a quitclaim deed, because you want to get all that after acquired property as well into the trust. And there's no concern about warranties, because really you're transferring it to yourself as trustee of the trust. So there's no concern of liability for any warranties.
All right, thanks. And in my own analysis 10 years ago when I thought about this is, if I do the quitclaim deed and then some shenanigans happen and some things come in later, it's not going to cover that. Whereas if I do the grant deed for the client, it's going to cover those things that happen after the fact. But I see lots of attorneys use quitclaim deeds, and I see lots of attorneys use grant deeds also. So the next thing we're going to get into is on the screen, and yes, I know I could have used PowerPoint. I actually chose to use Word on purpose for some reasons you'll see later. On the screen, you're going to see the next question, which is, what information needs to be included in the recording requested by on a deed? And you can see the first red box there says recording requested by. When I first learned how to create deeds, if you will, my mentor who taught me and taught me well, I appreciate, said just put attorney in there. You don't have to put your name and this or that, just put attorney. And for 10 years, I've recorded well over 1,000, close to 2,000 deeds and never had a problem. And then Placer County, who I've recorded deeds with, bounced the deed back and says, no, you can't put attorney in there. You have to have a name. So Greg, can you enlighten us to the government code that prescribes what you actually have to put in there?
Well, yes, I can. Thank you. Actually, there are a couple of government code sections which drive the format of the deed that you're looking at. They are Government Code Section 27321 and 27321.5. These together mandate that a deed to be recorded must contain the name of the party requesting recording. That's where our good friend Matthew got tripped up by the very officious clerk in Placer County, okay? Because of course, attorney is not a name, it's an occupation. As well, the deed must show the name and address of the party to receive the deed after recording, and the name and mailing address of the party that is to receive future tax statements. These are all driven by these code sections. As well, the format of the deed, he may, for historical reasons, is driven by another section, which I haven't bothered to quote to you. but it prescribes the format of how a deed is to appear, how wide margins must be, how much space you must allow for the county recorder's use at the top. These are all driven by statute as well. So there you go.
Thank you, Greg. And just to say it, folks, we will be passing out the speaker notes after this, and that will include the government code sections. So you're welcome to jot it down now, but you will get that information. The next thing I came across as I was recording deeds over the years is I'll get the source deed, which will have an APN in the legal description, and I want to include that in my legal description. But I notice when I get the county property tax bill, there's a suffix that's lots of times added, like a -00 or a -01. And these are more modern recorded deeds, like in the last few years. So the question is, can you omit the suffix, or do you always have to have the suffix on if you know it? And should you reform the APN that's included in the legal description to have the complete APN, if you will, as opposed to the abbreviated one that doesn't have the suffix on it? And I think Greg is going to answer this.
Okay. Well, first of all, I believe one of your questions was as well as to whether or not an APN is actually required to have as a valid part of a conveyance. Do you have to include it? Well, no. We pass as title companies deeds that slip by county recorders that do not have assessor's parcel numbers. The assessor's parcel number is not part of a legal description. It's a tax identification number, nothing more. However, there are two code sections, Government Code Section 297.6 specifically for LA County, and then 2729.7 for all other counties in California, which allows a county board of supervisors to adopt a resolution requiring that recorded deeds reflect the assessor's parcel number as the subject property. And hence that's where the requirement comes in, and that can trip you up at the recorder's office if you don't include an APN on your deed. As to the amount of digits that you should include in an assessor's parcel number, my recommendation is that you show every digit that has been assigned to it by the county assessor's office. That way, you will not run afoul of, again, some officious deputy recorder who happens to be very familiar with the amount of digits used by the county assessor in her or his county, and decides to reject your deed because it did not have the exact amount of required digits for that county.
And I apologize, I missed a fundamental question here. So Steve, if we don't include the APN, from a legal perspective, has title transferred at that point?
Yeah, for a deed, with respect to the legal description, all that's required is something that's sufficient to be able to find the property on the ground. And that, sufficient means a surveyor can actually take the deed and find that property. So as long as you have a legal description that allows that, then no, you don't need an APN. So it is valid. And then I think you had said something before about, well, do I have to go back and change these APNs? No, because here, as long as you have a sufficient legal description, the deed is in fact valid. So transferring into the trust, that is a valid transfer. And then maybe on the trust transfer deed, that's where you want to make sure that there's an APN, so then you can record that document.
Gotcha, thank you. And looking at the last field, we see the grantors. We have John Doe and Jane Doe. And the question is, can the estate planner omit the original designation on the source deed, if you will, from the grantor, such as husband and wife as joint tenants, or husband and wife as community property with right of survivorship, an unmarried man, a single woman, all the different designations? Can we just list their names? And the first question is, will that pass through the county recorder? And then the second question is that legal? And then we'll get to the title part as the third part. But let's start with, will it pass through the county recorder if we omit that descriptive language on the husband, on John Doe and Jane Doe? Greg?
Absolutely. It will convey title. So long as the parties identified as John Doe and Jane Doe are in fact the same John Doe and Jane Doe that acquired the property.
And then Steve, oh, sorry.
No, go right ahead.
Sorry, I was going to say, Steve, from transferring into the trust, omitting that language, is that going to be causing any issues from a transfer perspective into the trust? Any legal issues?
A grant deed is valid so long as you can identify the grantors. So here, presumably, if John Doe and Jane Doe exist, then it's a valid deed.
So then we get to the real thing, right? It's in the trust, it passed the county recorder, but now we need to sell it. So Greg, from a title perspective, does it cause issues to leave that information off where the title company is going to have problems with that?
It very well can. From a title insurance standpoint, the best practice in identifying grantors is to include their marital status as indicated on their acquisition deed. This causes this for us as title examiners, allows us to link those parties right off the bat. For instance, in this example, we have John Doe and Jane Doe. If they acquired as husband and wife, and then we're presented with this deed, we're not necessarily certain that the Jane Doe and the John Doe might not be different people. Okay. However, if they're identified as the same John Doe and Jane Doe, husband and wife, then that gives us a leg up in being certain we're dealing with the same parties. There's another reason for showing marital status. It could be that John Doe has a very nice sister named Jane Doe. And if she joined in the deed and we haven't captured the signature of Jane Doe, John's wife, that's problematic for a title insurer.
All right, thank you. Okay, so on to the next question. So this is a situation that, you know, a few years in practice, Alston and I had where the settlers of the trust come in and I look at the source deed and then come to find out wife's name is not what she used when she acquired the property with her husband. So the question is, if a source deed has a name for the grantor that has now changed, how does this estate planner list the new name on the trust transfer deed so that it will now record, it'll be notarized, and the new name, yeah, I'll stop the question right there. So Steve, you want to go ahead and talk about that?
Yeah, so fundamentally, as I was saying, for the deed itself to be valid, then it simply has to list the grantor and the grantee in a manner that they can be identified. So here, this thing would be valid because you can identify these people. The question, though, that you're really asking is the recordation. And to ensure that the property is of record title, what the deed needs to include is both the name of the grantor as they took property and the new name as it went out. And so looking here, the way this deed was done, you can see that the property was taken as Irma Vasquez took it as Irma Vasquez. And so it listed Irma Vasquez, who acquired title as Irma G. Vasquez. So that's appropriate. And then it lists the new name that she's sending it out as, which is Maria Irma Vasquez. So this is a correct way to do a transfer deed.
So in our talking, when we were preparing for this, one of the things I learned from you guys was, let's say someone is a junior when they buy the house, right? John Smith Jr. And now their father has died and they now are going by senior. This is a way to address the issue if they've changed from a junior to a senior so that it's still clear it's the same person and it's not a father and a son situation. So I'd never thought of that, but this is a way of handling that. Also, as notaries, I think we know we can only notarize what's on the person's ID. And if her ID says Maria Irma Vasquez, but the original source deed says Irma G. Vasquez, and that's what the county recorder is looking for a signature. This is how we are able to address this whole situation. Greg, did you have any more comments on this?
Yeah, there's a particular statute that in fact requires the grantor in this particular case instance to be identified exactly as she has been. Civil Code Section 1096 requires that a party acquiring in one name must identify themselves by that name when they convey out, okay? And so in this case, Maria has done exactly that. She has complied. She has shown the name by which she acquired, the name by which she is now known, and that satisfies. Had she not done that, that deed conceivably under that statute would say, even though the deed was recorded, doesn't impart constructive notice if only her present name is shown. So it's really important that that detail be attended to.
All right, thanks guys. All right, so we're moving on to the next situation here. So this is one that walked into my office. My client came in and said, Mom and Dad are dead, and now we need to sell the house. It was in a trust, purportedly in a trust. And so I started to look at the deed, and she actually brought in all of the deeds, amazingly. And we have a situation here where Dad created the trust, I believe, with a planner and had a deed recorded. And then the trust was amended, I think, twice. And each time, Dad took it upon himself to take the original deed and slap a cover page on it so that the county recorder would have something to record on. And then he took it upon himself. Oh, I'm sorry. I am completely in the wrong example. I apologize, folks. I completely got off in my brain. Okay, let's start with this one, the one we're actually on. Okay, so if someone owns a house, a partial interest in a house, how does the estate planner properly identify the partial interest in the house on the trust transfer deed, a grant deed, in order to properly place the partial interest in a trust? And Greg, this one is on you.
Well, first of all, title companies run into this problem of trying to determine from a recorded document exactly what the intent of the grantor was in these situations. In this particular deed, see, and I don't believe that we're on the right page of this deed, are we? We need to show how you want to convey, or how.
Yeah.
Okay. Well, in the example that we were talking about, Bobby Lee Fowler, okay, so he acquires with Tanya a 50% interest. They acquired as joint tenants. Now, oh, there it is down at the bottom, excuse me. Okay. In the wrong way example, you can see that if he conveys out describing himself as a married man as to an undivided 50% interest, conveying to himself as trustee, it's ambiguous. Is he attempting to convey 50% of his 50%? That's the ambiguity. And so the right way is being typified there is a preference that title companies would love to see, time in and time out. Why? Because it quantifies exactly what is happening here. Bobby Lee Fowler, an unmarried man, is conveying to himself as trustee of his trust the herein grantor's undivided 50% interest in and to the real property. That clears up in the mind of a title examiner the fact that only a 50% interest has conveyed. The title examiner can look back and see what Bobby acquired as joint tenant. Equal interests have to be acquired in that situation, so we're dealing with a 50% interest here.
All right. Steve, did you have any comments to add on this one?
No.
All right, just want to double check. All right. Moving on to the next example, which is still not the one I talked about. So we'll get there eventually, folks. All right. So if a client used the following grant deed language, which you can see on the screen, it's rough, and so I'll go through it, to transfer property into a trust, but did not identify the name of the trust that they were transferring their property into, would a court hold the property is in an unnamed trust or in the proper trust? And before I have Steve talk, let me go through the language in case it's hard to read on the screen. It says, for value received, Blanche Louise White grants to Blanche Louise White, trustee, under that certain declaration of trust dated January 7th, 1999, where she doesn't actually list the name of the trust. So Steve, from a legal perspective, looking at this, is that would a court hold that that's a transfer into her trust?
I think this is basically a contract analysis, and what the court would be trying to do is trying to identify that grantee to see if it's someone that they can ascertain who it is, because that language is in fact ambiguous. So where there's ambiguous language, then the court can go to extrinsic evidence. And in this case, if the evidence shows that around this date, Blanche Louise White was a trustee of a trust dated January 7th, 1999, I think that if that evidence came in, then yeah, court could make that determination that in fact the transfer was valid.
And then thinking about the next way of looking at it, Greg, how would a title company address the lack of the trust name in the transfer deed? Would they require us to go to court in your experience, or are there some alternatives?
Well, that's a pretty extreme position for a title company to take. I've only seen that taken where other facts in the chain of title would make us suspicious as to the particular conveyancing on a chain of title. In a situation like this, purely from a title standpoint now, our concern is, could there be another trust? Could she have multiple trusts of same date? And are we dealing with that particular trust in a subsequent transaction? And so the preference would be if one was going to clarify this of record, okay, is to convey in the fashion shown in the transfer deed portion of this example. Why? Because it tells the story. So Blanche is trustee of the certain declaration dated, is trustee of the certain declaration, grants to herself as trustee of her specifically named and dated trust, which revocable trust is the same as that certain declaration of trust dated January 7th, 1999, as set forth in the deed whereby she created the transfer to the trust in the first place. This tells the story. This connects the dots of record for a title insurance company.
Okay, so that answers the last question here, which is, if the settler's still alive, how can we clean this up? And I think if the settler's dead, then it goes back to what Steve said, as far as if it goes to court, how can we do it? And if Greg gets it, is there a way they can identify convincingly to themselves to be able to write a policy to support the transfer after the fact? So let's move on to the next question. Okay, now we're to that infamous question I quoted earlier because it was stuck in my head. And so we'll start over real quick here. So again, I had the client come into my office. Mom and dad were dead. She's the trustee of the trust. They want to sell the house and give the money to the kids. And looking through the deeds, you can see the examples here that I'm talking about. But in our source deed, we have it where dad, the estate planner, I believe, recorded a deed with the name of the trust in June 19th, 1998. Dad then, after an amendment, slapped a cover page on that actual deed. He then crossed out the date and wrote in the new date, July 13th, 2005. Then they did another amendment. So then Dad attached a new cover sheet to the deed, and then crossed out the second date and wrote in the new third date and actually recorded it. And so these are all recorded. So the question is, if the settler if it is found that the settler records these deeds, which appears to be changing the date of the trust with each subsequent deed, is the title company able to, or actually, I apologize, I'm going to stop there. Or no, I'm going to continue on. How will the title company address the lack? Well, I got to flip my page. I'm handling three things at once here. Is the title company able to underwrite the successor trustee of the original trust to sell the property, or does the court action need to be initiated to clean up before the sale can occur? And this is kind of going to Greg here. Is how does the title company deal with this kind of a situation?
Oh, pardon me. Well, I kind of have a two-part answer. The first part goes like this. The second and third recorded deeds with these strike-throughs, the title company is not going to accept those deeds at all. Why? Because, excuse me, the Westbergs left title as individuals by the source deed. They, as individuals, conveyed title to themselves as trustee of their trust. So now they have left titles as individuals. Now title is held by a fiduciary, the trustee of their trust, in that capacity. So their attempt to re-record on their own and merely strike through, for a title company, doesn't accomplish anything. These are wild deeds. The only person who could correct the deed of record as far as the title insurer goes would be a cooperative document between the Westbergs and themselves as trustees, so that you've captured all the interests that have the capability of playing with this particular title at this point. So we would not pass the second and third deeds at all. We would initially only deal with a representative, a trustee, purporting to act under the trust dated June 19, 1998. Okay. Now, as to how to resolve this problem, if the parties have died, and now it's presented to the title company to say, gee, we're trying to list the property, what do we do? Well, there's no cookie cutter answer. You'll find that different title companies may propose different documentation scenarios of record to paper the fact that a successor trustee under this trust is the successor trustee operating under the trust as amended as of 2008. However, what the title company is going to do is that they're going to want proof that in fact these purported amendments in 2005 and 2008 actually exist. We're going to want to forensically look at the paperwork and determine for ourselves that there have been proper modifications, amendments, restatements of the trust, what have you, in order to support our reliance on the act of a trustee trying to operate under this trust as amended and or restated in 2008. Now, if you can't satisfy me, being the nasty old title guy, okay, to that regard, then it could be that I might require that the Westbergs are going to have to go into court and get a final order, which in essence states that this property is now corpus of a particular trust, and what that trust is identified as, so that I have reliance upon the acts of a trustee operating under that trust.
All right, thank you. And I'll just ask real quick, Steve, did you have any comments on this one?
As I understood the question, your scenario, Matt, though, wasn't it true that this July 13, 2005 and the January 30, 2008, the trust never, those were never created?
Well, those were amendments, and
Okay.
at least in this scenario, as Greg points out, they didn't have the capacity to transfer it. I mean, the interesting question would be, which I'm not sure if we want to go into, is if they did have the correct capacity. So it was Raymond Westberg, Henry, Yetta Westberg, trustees of the Westberg Family Trust dated June 19, 1998, and then they transferred it to a later date. of an amendment and not an actual trust, then what happens then? But I think we didn't go into that in our research, so we're going to move on past that question. So now we're going to look at question number 10. All right, so if an estate planner is reviewing an older deed transferring property into a trust and finds the date of the trust is not included in the recorded document. So this time we have the name, but we don't have the date. Should the estate planner work with the client to have a new deed recorded that specifies the date of the trust? Or after the settler dies, will the property be able to transfer to the beneficiaries or sold without issue? So the first question is, when they come in, Steve, legally, has something been transferred to their trust? I think we should start there with that question, even though they omitted the date of their trust in the grant to field.
Yeah, and I think that it did occur here. I think that you can identify that it's John Smith, and John Smith again for his own trust. I think there's enough information there to deem this valid.
And then, Greg, from a title perspective, without the date, how do you guys handle that when we're trying to sell it after John Smith has died?
Well, title companies normally require the production of statutory trust certifications. And when we get that, that purports certain salient information about the trust, name of the trust, things of that nature. Normally, in a situation like this, it's in that document that the complete name and date of the particular trust is disclosed. So long as we are satisfied that there's no hanky-panky going on and that we are in fact dealing with that particular trust, then we will pass and insure a purchaser based upon a deed from the then trustee of this of the John Smith Irrevocable Trust, just in that fashion, identified just that simply. Or if in fact that trustee would elect to describe him or herself as trustee of the John Smith Irrevocable Trust dated a certain date, so long as that matched the trust certification, I have no problem with that. More is always better than less.
So the question comes in, and we have some time, so we'll go ahead and try to answer it from Deborah. If Mr. Smith is still alive, may we record a corrective grant deed? Either of you.
Should I attempt that, or is that to Steve?
Right.
Greg, go ahead and start.
Well, I believe that we've hit the scenario of one of our past deeds. Okay. The information could be, yes, it could be corrected of record. Okay, and that would be by a deed where if you wanted to roll back to your page 7 deed.
Yep.
Okay, as an example. Okay, there you go. Okay, so you could take a deed from the present trustee, identifying the trust as it is of record, and then conveying it to the trustee of the correctly named trust, stating that that correctly named trust is in fact the same trust as that appearing as grantee in the acquisition, in the trust acquisition deed. Hope that makes sense, but that's my answer from a title company. Okay, so long as I'm satisfied again that nobody's trying to take advantage of somebody else by doing this, then this is an apt way of telling the story in the record.
Yeah, and Matt, to add to that, I think again from a validity standpoint, you don't need the date to be included as part of the trust description. I think what the title company is looking at, they're looking to underwrite this thing, so they just want to make sure that everything matches up. And so you can either provide that information to Greg as the underwriter, and then he can say, okay, no, this all passes muster, and you pass it that way. Or I suppose you could be preventative and go ahead and do the corrective deed. But I think in most cases, simply providing the title company with the information they need is probably an easier way to go.
My experience, most people during the course of the escrow raise their hand and say, title company, well, what would make you happy?
Yeah, I'm in the school with Deborah, which is, you know, we do it right when we do it, and then we see a wrong one, what we deem to be wrong, come in, and then we're worried, should we be correcting that, or is it good enough, even though we would do much better in that situation if the client would have hired us in the first place. And that's where the angst comes in of deciding, making that decision, and what advice to give them in that situation. Okay, so now we're going to start to get into legal descriptions. So I've got some basic questions. So should the legal description always match 100%, even with spelling errors, the previous vesting legal description, meaning the source deed? Or can the estate planners use the correct spelling on a trust transfer deed in certain cases without going down the path of recording an actual correction deed and then recording the trust transfer deed? And so, Steve, let's start with you. What would be your answer to that question?
Well, I think as an estate planner or an attorney, you know, using the correct legal description is always the best practice. And so, yeah, you can go ahead and correct the errors. That's not an issue. It's not making any substantive change to anything. So I think you can safely go ahead and correct those errors, because you want the deed to be valid.
So, and what Steve's referring to is if you look at letter B and letter C on the screen, in my first example, California is misspelled, and he's saying that spelling California correct is not going to mess things up through chain of title. And the same thing in that same sentence in letter C, you know, it's TH instead of the. Go ahead and correct that. Then the next question is, at what point will the title company require a correction deed? Meaning, what's a minor change and what's a major substantive change? And that's where we're kind of getting into the conversation. So, Greg, do you want to weigh in?
Well, I agree with Steve on these particular. We see these frequently. You know, title companies attempt to be pragmatic. It doesn't appear like that to many of our friends when something pops up and say, gee whiz, why are you asking for that, title company? But in something like this, it's pretty obvious what the intent of the parties are. And so that's what the court's going to look at. That's what Steve alluded to. We take the same approach. When we encounter these kind of errors, inconveniencings and chains of title, we issue our reports using we correct and we show the right description. And we don't perpetuate problems like this, nor do we get cranky and say, you have to re-record, you have to correct your descriptions in error. That just doesn't make any sense.
Okay, so then let's start to get it where the rubber meets the road with the legal description. So I had a client come in and they brought me one deed and it was kind of hard to read, and I wanted to make sure the numbers, a 3 was a 3 and not an 8, and you know, things of that nature. So I had him bring in the previous deed, and lo and behold, I'm looking at both deeds, and the subdivision number, if you will, is not the same on both deeds. And so now, in my opinion, that's a substantive difference. And I don't know which number is correct. I'm not into that depth, if you will, when in estate planning. So let's see here, how do we work with this problem and correct it in order for me to be able to record a trust transfer deed that I'm confident is using the correct subdivision number when I record it? I think we're starting with Steve on this.
I think if I was a deed planner in this circumstance, what I would do to make sure that the trust transfer deed is correct is to get some sort of property profile order one from the title company. And so then I know what the correct legal description is, first of all. After I figure out if there's an error, then I would, let's just say it's the subsequent deed, the first one there, the 3880. Maybe that's the mistaken one, or something earlier in time. If that's an issue if that's creating some sort of issue in the chain of title, I'll look to see, if my clients are available right away, like let's just say it's the same grantor and they're just kind of transferring property around, then I could maybe do a corrective deed that way. I would work with my clients. Otherwise, if it's something where it's not within my control, it was some other party, then it depends on who prepared that other deed. And I would either have my clients maybe talk to the title company and say, please try to fix this if the escrow company made a mistake, or maybe they can go out and find the other grantor and grantee. But that's where I would try to fix the errors. So you have to look. There are a couple of things that are going on.
And then Greg, do you have comments on this?
I do. These typographical errors are critical to a title company. Misidentifying the number in a track can lead to an invalid deed being passed between parties. You have to correctly describe the property. If you have an incorrect track number, that's a substantial error. You've conveyed property perhaps in some other subdivision. Perhaps you've referred to a non-existent subdivision by making that typographical error. So this is critical. Title company approach, much like Steve. If the parties are still around, we would look for a cooperative and living available grantor to re-record the deed and correct the description. If that's not the case, if it gets really ugly, for instance, you have an obstinate grantor says, I'm not participating, okay? Or the grantor just is not available. Well, then you may be forced into a situation of the title company requiring a reformation action to prove, what is actually the title that's been passed by this deed. Now, I do have to say from another pragmatic standpoint, with the passage of time and a lack of attack appearing in the public record, and other information that a title company can gather by inquiry, what have you, and by having one's hands held by an indemnification, one could induce a title company to ensure a subsequent transfer using a correct description without remedial action happening in the public record. So does this happen? It does, okay? It depends upon the circumstances of a particular chain of title, but it is an approach that the title company will at least investigate a potential of pursuing.
Thank you. And I think obviously the answer is, if we see substantive differences, we need to stop and it needs to be fixed before we try to transfer that into the trust. All right, so question 13. If an estate planner is preparing a trust transfer deed and has two previous deeds that have legal descriptions that match substantively, but do not match in form, can the estate planner use the last recorded description, or do these need to be reconciled in some manner before the estate planner prepares the trust transfer deed? So if you can look at the source deed, the lot numbers match, the tracks match, the dates match, the books and maps and all that match. But in the subsequent deed, you can see they took out a lot of the language that connected it all together and basically used commas instead of the flowing language. So Steve, you want to comment on this?
Well, I think the question kind of answers itself. I mean, substantively, if the both legal descriptions are they match and they're correct, then I think, frankly, you can use either one, and I would use the most recent in time is generally what I've done. I've certainly, in my practice, I've always used the one that's insured, where there's actually a legal description and there's insurance behind it. Then I'll use that legal description because I know that someone else has looked at this and I can feel comfortable that that's the legal description that I should be using.
That's good advice. Greg, comments?
Happens all the time. Many changes of title are constructed in this fashion with these kind of inconsistencies, shall we call it. Title companies look for consistency in salient factors, as Steve mentioned. That's what we're looking at. Is do the vital statistics stack up? If they do, we're not concerned that somebody decided to excise what seemed to them to be superfluous language.
Okay, great. All right. So now we get to the fun stuff. All right, and this is the reason I've got Word on here. I'm going to try to blow stuff up as big as I can. So looking at the following example, what parts of the legal description would be used on the trust transfer deed, and what language, if any, on the face of the deed would be carried over the trust transfer deed? So this is going to be one of those long, this is the shortest example that I have of this. And what we're going to do is we're going to have Greg walk us through this deed of what needs to be in the legal description of the trust transfer deed and what should not be included in the legal description of the trust transfer deed.
Okay. All right. Well, first of all, we of course have a grant from Pulte Home Corporation to the Hoovers. For the legal description, we have to jump to Exhibit A, so that's where we go first. All right, so we have real property, state of California, Contra Costa County, city of Brentwood, described as lot 29 on this particular subdivision, okay? And then there is this clause reserving to the grantor, the Pulte Corporation, easements for underground utilities, okay? Now, in answer to the question, what would be a sufficient description on a subsequent deed out? Whether it be to a third party or to their own trust. I believe that you have an example, which I've asked you to show, and I believe that's on the next page. So if you scroll up to that, okay, this is a very sufficient description of this property for subsequent conveying purposes. And now I'll go back, and now we'll go back into the deed proper, and I'll tell you why I believe that to be the case. Okay.
Let me go to the first page, Greg.
Please go to the first page. Okay. All right. So stop there, please. Thank you. Okay. So in reading the logic of the composition of the document as drafted, we've examined the legal description, and now we start reading the narrative. And the first long-winded paragraph is an imposition of covenants, conditions, and restrictions contained in these various recorded documents. The next paragraph is the reservation of an easement, again by the Pulte Home Corporation, of what I'll call the golf course easement, okay? And so that is an easement. And let's continue to the next page, okay? And so on this page, we have another reservation to Pulte Home Corporation of another easement. Okay, and then finally we scroll back down to the legal description again. And now in reading the legal description, we find that after the lot's been described, the Pulte Corporation again, the grantor, has reserved underground utility easements. Okay. The imposition of the CC&Rs, the reservation of these three easements create encumbrances to the title conveyed. They are not reducing the amount of the land conveyed. They are imposing encumbrances, charges on the title, which the Hoovers have agreed to accept their title subject to. So they are really not proper substances of the legal description. The legal description is the land that's conveyed. And so after you forensically take a look at this deed in that fashion, what is the legal description for proper conveyancing purposes subsequently? It's purely lot 29, okay? And this is what title companies do, by the way, folks, is that we encounter these first deed out in common interest subdivisions all the time, and that's what we have to do. We have to parse the document, and in order to reflect in our title reports, what is the land that we want to insure? Well, the land that I want to insure is lot 29. I don't want to insure lot 29 reserving an easement, okay? I want to insure lot 29. And so that's how I prepare my preliminary title report. And of course, as we all know, when you go through escrow, that becomes the source document from which a legal description is then used for the transactional documents, okay? So that's why I say the proper legal or subsequent deed out is just the description for lot 29.
Greg, we have a little bit of time. Do you want to go into a little bit of more detail of, I apologize, the words have left my head, why those aren't things we would carry forward in the out deed versus things that we would carry forward in the out deed. I know you've been brief and we appreciate that, but we actually have a little extra time. So do you want to describe that a little bit better? Or Steve, would you like to?
Are you pitching the question back to me, or is it going to Steve?
Well, first let's pitch it to Steve real quick.
Okay.
I think, you know, it's interesting. There's a question and answer here. There's one comment by John Deanna that says that he was advised by his malpractice company to not change anything in the legal description, but to give the client the option to have a surveyor provide the correct legal description. Then you could use the surveyor's description. Otherwise, use the same exact description. And I think that as a practitioner, if I was faced with this sort of description, yeah, I would be careful about excluding things. You know, even in my practice, I'd be careful about excluding things I wasn't sure that I should be excluding. It's better to be safe and use that description.
So Greg, go ahead and continue forward.
That's fine legal advice. I don't tilt lances with that at all. Okay. However, there's going to be a lot of cost associated with that. And there is another mechanical opportunity that happens if you take this legal description that we're looking at this page, and you put that and you include that in the conveyance into your deed that's going to transfer the title into your trust. Okay, of course, it's going to be recorded. If you use this description exactly, including the reserved easement language, and you do not define the grantor as being the Pulte company or the Pulte Home Corporation, then the only grantor in your deed is in fact the Hoovers. And so in essence, a title examiner looking at that subsequent deed will, by all rights, take an exception for this easement reserved unto the grantor, the Hoovers. And so you are going to repeat an easement. And not only that, you're going to repeat an easement which really doesn't possibly belong to the Hoovers to retain in the first place. Okay, so I just point that out. That's why title companies do what we do. Okay.
Yeah, and I would say I've heard the exact same thing of just mirror the language. But I want to bring this up to say that if you do that, like Greg's warning, if you think about who the grantor is and you mirror it through, but you actually think through what you're doing, it's probably not accurate. And so possibly on a deed like this is where, like the participant suggested, you get a surveyor, or possibly you work with the title company to get the correct legal description so that it is accurate, as opposed to putting reservations into the Hoovers that can't be done.
One small caveat to that last piece of advice: if the title company is going to get involved, they're going to want to write a title policy. We don't give advice. Okay.
Gotcha.
So that could cost your client some money. Okay. Now, if you go back to the same title company, that insured, in this case, the Hoovers, okay? Perhaps that title company would be warm and fuzzy, work with you, and recommend a legal description for the conveyance, and then endorse their policy to date it down, and therefore you might get some, that would allow the title company to work with you within the confines of really not practicing law, okay, and still being able to help your client out. I just want to point that out.
Thank you, Greg. Looks like we have another question. Let's see here. The question comes in, could we put the legal description without the restrictions, but indicate, subject to the restrictions imposed by the deed recorded X date or something along those lines? We're actually, I think that's, well, go ahead and comment on that, guys, if you'd like. We'll start with Greg on that.
Well, I think that question will be answered if we look at the next deed and then the final question. Okay?
All right, so you want to hold for that one.
So I'm happy to go there. I think that an answer will be forthcoming. And if those two facets of our presentation do not solve the question, let's have the question repeated at the end, and we'll tackle it then. That would be my recommendation.
All right, we'll go in that order. All right, so we're going to go ahead and hold that question. We'll look at the next deed. And again, the question is, what is the legal description we're going to use according to a title company's analysis of transferring this into the trust? So I'm going to get as much as I can on the screen here. And Greg, you're on for this one.
Okay. Well, again, we just take you start looking at the organization as the document was drafted. So we look at the parties, of course. We have the RVCP LLC as grantor conveying to the Olsons. And what do they convey? Well, they convey parcel 1, fee simple title in and to lot for legal description, see Exhibit A. Okay, so let's go to Exhibit A. All right, now, so it's property in the city of Rio Vista, County Solano, State of California. Lot 26 is shown on this particular subdivision map, accepting therefrom. And now we have about 4 or 5 pages of things that have been accepted from this legal description, okay? I'm just going to go through a couple because talking about a couple mirrors the balance. So starting at the top, accepting from that portion of this lot lying within parcel 1 described in a deed recorded in 1990, the following happened. What was it? A mineral rights estate was reserved from a portion of this lot, okay, and then you read down, and in the middle of it, you find out that it was accepted in a deed from William Marks, in a deed recorded, let's see, 1957, okay, and so you have a mineral rights estate that's been reserved. Let's go to the next paragraph, the parenthetical 2. Well, this is again another mineral right that was accepted now in another instrument by other parties. I'm not going to bore everybody by trying to glean who these people are, but now let's go down to number 3. Okay, and so we have another mineral estate. So let's go down to the next page, please. And in there, we'll find out who reserved this particular mineral estate in a particular recorded deed. This happens throughout the rest of this legal description, okay? And if you scroll to the end, so what do we have? We have probably about 4 or 5 pages of legal description. Okay, finally we get to the end, okay? So what is the legal description from a title insurer standpoint for this lot? It is this entire legal description, this entire Exhibit A. This is a different situation from the previous deed, pardon me, to the Hoovers, where we had a lot being conveyed, and then we had a reservation of an easement. Okay, again, the reminder there is that an easement doesn't subtract from the land conveyed, it's an encumbrance to that title. It's a charge being imposed on the title. It doesn't reduce the amount of the fee title conveyed. Mineral estates, water rights are different. Why? Because they are in fact reducing an estate or interest or even an amount of land in connection with the creation of a mineral rights estate. A mineral rights estate is subtracted from the entirety of the surface of the land from which it's extracted, from which that estate is created. So therefore, from a title company's standpoint, this is not merely the creation of encumbrances on a title. All of these mineral estates are subtractions from the lot as conveyed, and therefore, we're going to repeat this description. Okay. So now if you go back up into the body of the deed proper, okay. All right, we'll stop. So now what is happening here? Well, first we have a category of reservations. Well, perimeter easements. Okay, well, I'm not going to bore you again. An easement is an encumbrance from a title company's standpoint, not a reduction in the land, a charge on the title conveyed. So now if you scroll down, okay, we have exceptions. Well, I don't think the caption tells the truth here, really, because when you read the nuts and bolts, what this is describing is a situation where an accommodation agreement has been entered into by parties. It's described in this deed. And what this accommodation agreement is, as you folks can tell, from all of those mineral rights reserved, there's a good chance that there's active minerals being exploited in this area. This accommodation agreement is, and I have not read this one before, but I bumped into these things all the time. What this accommodation agreement probably is an agreement between the mineral rights holders and the owners of the surface of the land, which was the developer, and now it's going to be these folks that have bought this lot in this subdivision, whereby those parties, the estate holders who want to exploit their mineral estate and the surface owners who don't want their home destroyed by having a derrick, constructed on the surface of the land to allow for the exploitation of the previously existing mineral estate. So the accommodation agreement basically says, okay, I know you're going to drill. I know how you're going to drill. You can drill just so long as you don't disturb my house and maybe the depth of my land down to a certain amount of feet. Okay, now I'm making a guess here, but that's probably what this is doing. So now let's keep going. Okay, and so now we have these underlined paragraphs. Conveyance subject to accommodation agreement, accepting accommodation agreement, general release, declaration, and restriction. Let's go to the restriction, let's scroll it up, and maybe you can blow that up.
Nope. That's as big as I can make it, and then
Okay, well,
sorry,
fine.
I got to get back to it.
and
Yeah,
go
give me a
on.
minute here.
Okay.
I'll get there.
All right.
I apologize. I tried to do it. Give me one more minute. All right, right there.
All right. Well, for those, hopefully you can read, audience. If you can't, I'm going to quickly read this restriction. It is important. No subsequent grant or conveyance of all or any portion of or any interest in the real property conveyed by this grant deed shall be made, unless that grant deed or other document of conveyance both A, contains this paragraph and the foregoing 4 paragraphs, and B, is duly executed by the grantee or transferee under that conveyance. And then it goes on to say that this is a restriction running with the land. Okay. This is an imposition of lots of encumbrances to this title. And I, as a title officer examining this particular title, would have to go through and look at all of these documents mentioned here, and again, forensically decide what I'm going to decide is an encumbrance on title versus what has to be shown in the legal description. Remember, I'm going to be asked to ensure a legal description, so I'm charged to do this. And so I know that all of that stuff before are imposing encumbrances on the title. Now I get to this matters of record. What is this? Okay, well, this is again imposition of the land here is conveyed subject to all of these matters set forth in these recorded documents. Okay, again, I'm charged. I have to look at these. I have to make a decision. Do they subtract from the estate conveyed, or are they merely encumbrances on title? Okay, so at the end of the day, to answer your question, my subsequent legal description, my report is going to be that entire Exhibit A. I am not going to be showing these matters because I'm presuming I've done my job right, presuming I've looked and made proper determination. I've determined that all these things are encumbrances to title, not reductions in the estate conveyed. They have lessened the bundle of sticks conveyed in the land described. Okay, and that's how the best way I can describe how I approach this kind of a deed. Okay. Now, perhaps now's the time to answer the question. And the question was, well, can I simply put in a statement subject to all covenants and conditions of record or something to that effect? I forget the exact question posed. I hope I've kind of hit the nail on the head. If I did, then that question is very analogous to our last question here. Okay, and so why don't we just start with this question? Okay.
All right, so our final question is, can you include as subject to any restrictions, conditions, covenants, rights of way, and easements now of record language on the face of the deed? And if so, does that entitle you, what does that entitle you to skip, meaning not use out of the source deed? So Greg, go ahead.
Okay. First of all, I'm going to react to this question. Can you include this? Well, I know from a title insurance standpoint, I know of no prohibition that says that you can't include something like this. Okay. What is my reaction to this? And we encounter these statements in conveyances all the time. The reaction from a title insurance standpoint is, this is a so what? Okay. I ignore this. I do not accept it from coverage, okay, because it is so very general. Okay. Now that's from a title insurance standpoint. Steve mentioned early on when we go back and talk about the difference between a grant deed and a quitclaim deed. And a grant deed contained the 2 implied warranties. The warranty that I, the grantor, own the property, okay, and I'm conveying my property, okay. 2, that the implied covenant that I've disclosed to you those things that I've done to the title. Well, I've owned it, okay, those are the implied warranties. Well, if you look at this particular statement, now, okay, I got to back up. From a title insurance standpoint, not only do I ignore this, I won't make a statement from a title insurance point of view as to what the effect of this is. Okay, that's not my job. Okay, that's Steve's job, and perhaps Steve will go there. I'll make a couple of observations though. My observation number one is that if this is an attempt to perhaps generically create a shortcut to take care of that one covenant of disclosure, as I call it, that's implied in a grant deed, then this may not be satisfactory, because when you look at the code section that creates the implied warranties, it's not limited to matters of record. The grantor has an obligation to tell both record charges that they've created and unrecorded charges that they've created to a title during their ownership. So my observation is this may not work, okay? My second observation is looking at the deed that we just left, the deed to the Olsons from the RVCP. This kind of a statement probably is not going to live well in the face of that restriction, which said that the Olsons have promised in that their subsequent conveyance is going to contain that restriction. And that restriction was very long-winded, as we remember. This, I don't think, well, no, okay, I've made my observation and I'm going to leave it there.
Steve, do you have comments on this type of a statement?
No, I agree with Greg. I don't know that this language certainly doesn't change anything legally. I mean, you're sort of subject to whatever you're subject to, and this language doesn't change that. And in fact, and so as we're looking at the two prior deeds, the things that need to be left in should be left in and not. And I don't think this changes that.
Okay. All right.
Matthew?
Yeah, go for it.
If I may, perhaps in answer to the question that was posed, in my notes, folks, that you'll get a copy of, in answer to the question 15 in that very complicated deed, I have made what is only a suggestion. It's a suggestion made from seeing a lot of experience or experiencing a lot of conveyancing that uses a particular method to perhaps address a very complicated deed, such as the item 15 deed. And that would be to have a legal description that would convey that lot 26 of that map of trilogy as described in the deed to the Olsons from the RVCP Delaware Corporation by document recorded, subject to all of the terms and provisions thereof incorporated herein by reference. Okay, now what you've done is what I've told you is that I, as a title insurer, will use the long-winded legal description. Would this kind of a conveyance that I have just described, would that work? Yes. Why? It conveys a lot, and all the rest is, from a title insurance viewpoint, surplus. The lot's been conveyed. And it is very proper, there's precedent decision that you can convey property by making reference to another recorded document, okay? For instance, one could convey this title acquired by the Olsons by a deed that read, and let's use a trust transfer deed, that the Olsons as individuals transfer to themselves as trustees of their trust, all that real property described in the deed from the RVCP LLC Delaware Company to the Olsons recorded in deed such and such and such and such, period. That's a valid conveyance. Okay. We pass on that when we encounter those. And in fact, I'll go you one better. We pass conveyances that do the following, where party A grants to party B all their real property in the county of such and such in the state of California, period, end of story. That too is a valid conveyance. Because there's no mistaking what's been conveyed. It's all the land that they owned in the particular city and the particular county, particular state. By the way, folks, for you that are involved in preparing your legal descriptions, the two salient things that you always need in a legal: state and county. City is extra, it's icing on the cake, okay? You need city and county. But that deed in that fashion, would I pass as a title insurer? Yes, I would, I have.
Okay. Thank you, Greg. Steve, did you have any final comments? And then folks, we have time for some questions. If you want to type up your questions, we'll go ahead and answer those right now.
No, I don't have anything further.
Thank you, Steve. All right. Let's see here. Ann and Catherine.
All
I'm
right.
here.
All right, and we're back finally. Thank you very, very much, Matt, Greg, and Steve. And so at this point, we are going to conclude our annual symposium. Anne, did you have any other announcements for from the Bar Association? Other
Yeah,
than
I do not. I just thank the estate planning section for putting this on. Awesome presentation. I'm just noticing there's some Q&A. Did you guys get all those? In the Q&A, did you see the questions in the Q&A?
Yes, those
Okay,
three questions.
okay.
Yeah.
Okay, sorry. Just wanted to
Okay.
make sure. Okay, it looks like we're all good and nothing left in the chat. So thank you, everyone. And hopefully we'll see you next year.
And Anne, I also want to extend a very special thank you. This could not have happened without all of the hard work that you did, and we appreciate it very, very much. Thank you.
You're welcome.
Thank you. Thank you.
Thanks, Ann.
Okay.
Okay,
All
guys.
right. Thank you.
All right. Thanks, everybody. Have a great rest of the day and weekend.
Yep, bye.
Shall the presenters hang in, or are we free to go, or what's your preference?
Oh,
We're free to go, I believe.
you lost the other guys.
Well, Steve made his decision. I think I'll follow Steve's. Goodbye,
Hey,
folks.
Matt,
Thank you. Thanks
let
for
me
the
ask-
invite. It was a pleasure to participate.
Thank you, Greg.
Thank you, Greg. It was great having you. I wanted to ask Matt a question. Oh, we're still live. We're still,
We got 27 voyeurs right now.
we got left in here. You want to just, you can just chat, call you.
Yep.
Okay, I'll do that. Okay, thanks a lot.